amended shall be considered as read. The previous question shall be considered as ordered on the resolution as amended to adoption without intervening motion or demand for division of the question, except 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Rules.
The gentleman from Maryland is recognized for 1 hour.
Mr. Speaker, thank you very much. For the purposes of debate only, I yield the customary 30 minutes to the gentleman from Oklahoma, pending which I yield myself such time as I may consume. During consideration of this resolution, all time is yielded for the purposes of debate only. I ask unanimous consent that all members be given 5 legislative days within which to revise and extend their remarks.
Without objection.
Mr. Speaker, on Monday, the Rules Committee met and reported a rule, H.R. 431, providing for consideration of H.R. 2740, making appropriations for the Departments of Labor, Health and Human Services, and Education, and related agencies for the fiscal year ending September 30th, 2020, and for other purposes, and House Resolution 430, authorizing the Committee on the Judiciary to initiate or intervene in judicial proceedings to enforce certain subpoenas and also for other purposes. The rule provides for consideration of H.R. 2740 under a structured rule, self-executes Chairwoman Lowy's manager's amendment, and makes in order 106 different amendments. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking members of the Appropriations Committee, and provides that they may offer up to 15 pro forma amendments, each for the purposes of debate. The chair of the Appropriations Committee may also offer amendments en bloc, consisting of amendments made in order by the rule and not earlier disposed of. Additionally, the rule provides for consideration of House Resolution 430 under a closed rule, with 1 hour of debate equally divided and controlled by the chair and ranking members of the Rules Committee. Mr. Speaker, this rule pairs 2 bills which demonstrate the commitment of the House majority both to make strong progress for the American people in the areas of health, labor, and education, at the same time that we defend the Constitution of the United States and the rule of law against the obstructionism and the lawlessness of the executive branch of government. Let's start with H.R. 2740, which is designed to make government work for our people. It provides $189.9 billion in discretionary funding for the Department of Labor, the Department of Education, and the Department of Health and Human Services. It increases investment in the National Institutes of Health, our country's preeminent medical research agency, a national treasure, which is headquartered in Bethesda, Maryland, in my district, to support research for Alzheimer's disease, HIV, AIDS, breast cancer, colon cancer, cystic fibrosis, multiple sclerosis, childhood cancer, heart disease, stroke, diabetes, mental health, suicide prevention, the Cancer Moonshot Initiative. The people of NIH and their network of allied entities and agencies and supported universities and research labs across the country are making profound progress in the struggle to uplift the health of the people against all of the killer diseases of our time. And for the first time in more than 20 years, this bill contains funding to support gun violence and firearm injury prevention research, and we are proud of that. This legislation increases funding for Department of Education programs to help America's children succeed, providing critical resources for elementary and secondary schools, special ed programs, and federal student aid. Importantly, the bill increases the maximum Pell Grant to help America's college and graduate students keep pace with inflation and the high cost of living. H.R. 2740 also provides $56.4 billion in funding for the State Department, USAID, and the U.S. Institute of Peace. We're making major strategic investments in diplomacy, global health, and international basic education, the crucial ingredients for maintaining peace and security around the world. This legislation provides essential humanitarian assistance and critical funding to improve maternal and child health, to fight diseases like malaria, and to support women's reproductive health and literacy across the globe. We know that the key to improving social and economic development around the world is the education of women and the investment in family planning programs and literacy about procreation. Additionally, this legislation renews our nation's commitment to addressing the climate crisis by investing in directives on adaptation and renewable energy. It also prohibits the use of any government funds to withdraw from the Paris Climate Agreement. Now, on the other legislation, which deals with contempt, Mr. Speaker, we know from Special Counsel Mueller's report that there was a sweeping and systematic assault on America's elections in 2016. There was a conscious effort and plan by Vladimir Putin and the GRU to undermine and destabilize the American elections by interfering and hacking into the Democratic National Committee, the Democratic Congressional Campaign Committee, Hillary Clinton's offices, to inject poisonous ideological propaganda into the body politic of America through Facebook, through Twitter, through YouTube, and other social media entities, and then to directly hack into the state boards of election. The Department of Justice launched a special counsel inquiry. It was a Republican attorney general who named a Republican special counsel, Mr. Mueller, to do it. The President of the United States, according to Special Counsel Mueller's report, engaged in at least 10 different episodes of efforts to interfere with that investigation, to obstruct justice. And we received that report a couple months ago from the special counsel. In the aftermath of it, President Trump said, quote, "We are fighting all subpoenas," and declared that there would be no cooperation from the executive branch with legislative branch subpoenas, with our demands for documents, with our demands for witnesses, with our demands for testimony from the executive branch. He said, "I don't want people testifying, and there is no reason to go any further." And since then, they've drawn a curtain down over the executive branch of government and defied the lawful orders of the Congress of the United States. The Trump administration is stonewalling from pillar to post congressional investigations, defying validly issued congressional subpoenas. So, for example, Attorney General Barr is refusing to produce the full unredacted Mueller report and the related underlying evidence to the House Judiciary Committee. Every other independent special counsel had simply turned their report over to Congress, and Congress did the redactions. But Attorney General Barr engaged in a series of games with the Congress of the United States and confused the American public, as Special Counsel Mueller complained in a letter that he sent to the Attorney General. He is also defying a House Intelligence Committee subpoena, directing him to turn over documents and materials related to Special Counsel Mueller's investigation, including all counterintelligence and foreign intelligence materials produced during the investigation. Don McGahn, the former White House counsel, has defied a subpoena issued by the House Judiciary Committee without any substantial legal basis at all. Treasury Secretary Steve Mnuchin is defying a subpoena from the House Ways and Means Committee, directing him to produce the president's tax returns under a statute which makes it crystal clear that Congress has a right to obtain the tax returns of the president or any other citizen of the United States. Commerce Secretary Ross and Attorney General William Barr are refusing to comply with duly authorized bipartisan subpoenas from the House Oversight and Reform Committee, which is investigating the administration's shadowy and illicit efforts to add an illegitimate citizenship question to the 2020 census, completely outside of the Administrative Procedures Act process, and several district courts have struck that down. But in any event, the administration is refusing to turn over evidence, relevant evidence to Congress about this effort to impose the citizenship question on the census. The administration is refusing to turn over documents, witnesses, and testimony relating to the corruption of the security clearance process in the White House Personnel Office. There were 25 different individuals who were denied security clearance by the professional staff in the White House Personnel Office, who were then overruled by President Trump or political appointees. We are trying to get information as to what was the basis for the original denial. It was likely conflict with foreign governments or financial conflicts of interest. It might also have been drug or alcohol problems, but we want to get the details of each one. And then we want to know if there's any written documentation of why the president and his subordinates overturned those. In all of these cases, Mr. Speaker, the executive branch of government has followed President Trump's orders to say simply, we're not going to turn anything over to Congress. Now understand, the Supreme Court of the United States has held that it is an essential and integral aspect of legislative power to engage in investigation and fact-finding. That's how the people's representatives are able to legislate. We are able to get information. But if you shut down our ability to get information, we cannot engage in lawmaking. And for that reason, we've begun to win in all of these federal district court cases where we're going out to try to get this information. But Mr. Speaker, we cannot tie up the floor of the House of Representatives every time the executive branch decides to follow the order of the president and simply deny us the information that we seek. My friends across the aisle know from the Fast and Furious investigation, the Hillary Clinton email investigation, the Benghazi investigation, it is Congress's right to investigate and to obtain the documents that it wants. And they obtained millions of documents in those investigations. And we had a right to get them then, and we have a right to get all of these documents now. Mr. Chairman, this legislation will give the power, first of all, to the Judiciary Committee to follow through on the subpoenas that it is issued. It will also empower and authorize each chair of the House of Representatives to enforce their lawful subpoenas that are being dishonored and violated by the executive branch of government. So we're very proud to bring forward these two pieces of legislation, one which makes good on our commitment to the American people to continue to make progress in the fields of education, healthcare, labor, scientific and medical research, at the same time that we defend the Constitution, the rule of law, the prerogatives and powers of Congress against the lawlessness and the obstructionism of this administration. We are the preeminent and primary branch of government. The very first sentence of the Constitution, Mr. Speaker, we the people, in order to form a more perfect union and establish justice and ensure domestic tranquility and provide for the common defense and promote the general welfare and secure the blessings of liberty to ourselves and our posterity, do hereby and ordain the Constitution of the United States. The second sentence that follows is all legislative power is vested in the Congress of the United States. The sovereign power of the people comes right through the preamble into Article 1, establishing us as the representatives of the people. And then you get dozens of paragraphs setting forth all of the powers of Congress to declare war, to raise revenues, to write budgets, to impeach the president or other executive branch officials who commit high crimes and misdemeanors, and to remove them in the Senate, to set up a post office, to govern the seat of government, and to establish a capital city. Those are the prerogatives and powers of Congress. Then you get to Article 2, and Article 2 fixes the powers of the president. And what is the president's core responsibility? To take care that the laws are faithfully executed. That's the president's job, to take care that the laws are faithfully executed. And it's even in Article 2 that the president can be impeached in Section 4. Just to make clear, the president works for the Congress doesn't work for the president, and we, the Congress, work for the people. That's what it means to have a representative democracy. We work for the people. Now we have a president who is in an unprecedented, wholesale, categorical defiance of the powers of Congress by denying us the information that we seek to obtain, which is our right and which is our need. And we are going to get it, and we're going to get it by empowering Congress to go to court to enforce our subpoenas. I'm happy to yield, and I reserve the remainder of my time.
Members are reminded to refrain from engaging in personalities toward the president, and the gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker, and I want to thank my good friend, the gentleman from Maryland, Mr. Raskin, for yielding me the customary 30 minutes. I yield myself such time as I may consume.
Gentleman is recognized.
Thank you very much, Mr. Speaker. I hadn't had this in the opening, but I want to disagree with my friend right off the top. The President of the United States does not work for the Congress of the United States. He works for the American people, and he heads up a branch of government that is a co-equal branch of government. So on that, we'll have a long discussion. But it's been a very eventful week, Mr. Speaker, in the Rules Committee, and it's only Tuesday. Last night, the committee met and reported out a rule that covers two drastically different measures. H.R. 2740 is an appropriations package which covered first 5 and then 4 of the 12 appropriations bills for fiscal year 2020. We also considered H.R. 430, a resolution that gives authority to the Office of the General Counsel to seek to enforce certain subpoenas for documents through litigation. Shortly after we finish here, the committee will again convene to consider the remainder of the appropriations package, which will be on the floor as part of a separate rule tomorrow. Meanwhile, our members will attempt the miracle of being in two places at once as we continue to debate HRS 430, which falls into our original jurisdiction here on the floor. House Resolution 430, Mr. Speaker, comes from a dispute over documents relating to the special counsel's investigation into Russian interference in the 2016 presidential election. The dispute also stems from the inherent oversight authority Congress and our ability to perform oversight functions over the executive branch. And it falls into the fuzzy boundaries between the branches of governments. When and how we may compel the executive branch to turn over documents to the legislative branch. I lay out that framework because there's an important point here that's being lost. The Democratic majority clearly wants to make this dispute entirely about this president, this attorney general, this White House counsel, this investigation, this subpoena of documents. The Democrats want to focus attention there because they think it helps them politically to do so. But this dispute really shouldn't be about just that. It should rather be about the difficult and thorny questions that emerge in a system like ours with three branches of government with checks and balances. In a sense, what the majority is seeking to do here today is completely unprecedented, both in its intent and in its execution. Consider the only other times the House has filed a lawsuit to seek to enforce a subpoena for documents. It's happened twice before, Mr. Speaker, once in 2007 to seek documents from the former White House counsel Harriet Miers, and again in 2012 to seek documents from then Attorney General Eric Holder as a result of the congressional investigation into the Fast and Furious scandal. In both of these cases, the House had already voted to hold both Miers and Holder in contempt of Congress before filing suit, which has not yet happened in this case. In the Miers case, 138 days elapsed from the first document request to the Judiciary Committee voting to hold her in contempt. In the Holder case, it was significantly longer. 464 days elapsed from the first document request to the committee voting to hold him in contempt. That was well over a year. But here, the majority is forcing us to rush forward at a much faster pace. Just 44 days elapsed from the date of the first document request to the Attorney General until the Judiciary Committee voted to hold him in contempt. 44 days. James Holzhauer has been champion of Jeopardy for longer than that. I don't understand the majority's haste here. Without exhausting all other options, continuing negotiation, discussion, compromise, and turning to a vote on contempt as the last resort, the majority is instead pushing us forward into litigation with the executive branch. And in doing so, they may well be placing the House in a position that causes significant long-term damage to the institution. When this matter goes before the courts, it will do so as a case of first impression and under an untested legal theory. In both the Miers and Holder cases, the House previously voted to hold those two individuals in contempt of Congress. Nothing like that's been done here, and using untested tactics like this could set a dangerous precedent that harms us all, Republicans and Democrats, in the long run. Finally, I would also note that it's not clear what this resolution will ultimately accomplish. Since the House has not yet exercised all the tools in its toolkit, and since it's not clear that the negotiations with the Justice Department and the White House over the documents at issue is at an end, this whole thing may be nothing more than sound and fury. Indeed, given how quickly the majority is rushing into things, it seems unlikely that the only course of action left to the House is to file a lawsuit. I strongly urge the majority to continue working with the Justice Department and the White House to find a resolution to these issues without resorting to knee-jerk lawsuit that may ultimately damage the House as an institution. Today, we're also beginning consideration of H.R. 2740, an appropriations package covering 5 of 12 appropriations bills: labor, health, and human services, and education, the legislative branch, defense, state and foreign ops, and energy and water. These 5 bills cover over 70% of our total discretionary spending for the fiscal year 2020. Well, to be precise, Mr. Speaker, we were to do 5 bills. At the last moment, the majority pulled the legislative branch appropriations bill. I'll let them explain why at their leisure. As a longtime member of the Appropriations Committee, I'm pleased that we're beginning to move the appropriations bills to the floor. Unfortunately, the bills here before us have some numerous flaws, most notably that they are marked to allocation levels that aren't realistic. As we move forward through the appropriations process, I think we need to be clear about the challenges we face this year. At the end of September, the FY 2019 year expires, and sequestration cuts contained in the Budget Control Act 2011 will automatically take effect for FY 2020. In order to prevent that, we need to come to a bipartisan, bicameral budget deal that the House, the Senate, and the President can all agree on. If we don't, then it doesn't really matter what fake number the House marks to. Sequestration will hit, and our defense budget will automatically be slashed by 11%, and our non-defense budget by 9% below the allocations of 2019. The spending levels in these appropriations bills are not just ambitious, they are unrealistic. Not only are the funding levels for many of these bills too high, so high that the Senate and the President will never agree to them, but the allocations the Appropriations Committee used to reflect the misguided notion that any increase in defense spending must be matched by an increase in non-defense spending that is more than twice as high. That's simply not a realistic assessment of our national priorities or the physical limitations imposed on us by our rising national debt. The defense provision of this bill, for example, comes in at $8 billion less than the President told us was needed to adequately fund the military, maintain readiness, and be prepared to confront international threats. After years of severe underfunding of our armed forces, and at a time when threats are emerging everywhere from around the globe, spending less than the administration asked for on defense in order to push more money into domestic programs is not a wise course of action. I'm disappointed that the majority chose to strip out pro-life provisions that have been carried in appropriations bills for years. Instead, they added controversial pro-abortion riders that virtually guarantee no Republican support whatever for this package. As the former chair and current ranking member of the Labor, Health, and Human Services Subcommittee, I'm familiar with the need for compromise on that particular piece of legislation. But by pushing forward with blatantly partisan riders like these, the majority is guaranteeing the outcome of these bills, dead on arrival in a Republican-led Senate and no chance of getting a Republican president's signature. In the coming months, I hope we work through these problems, frankly, as we did last year. The majority intends to move forward with unrealistic spending levels and insists on maintaining partisan riders, then we're simply guaranteeing a failed appropriations process. And make no mistake, Mr. Speaker, our failure has consequences. A best-case scenario in a year-long continuing resolution that funds the government at the exact same level as the current year. That's the best scenario if we fail. Worst-case scenario is another government shutdown or sequestration that cuts or sequestration cuts that automatically cut all government funding levels. Neither of these is a good outcome for the House as an institution, for the federal government, or more importantly, for the American people. Mr. Speaker, although I cannot support either bill before us today, I am hopeful that we will eventually reach a bipartisan, bicameral compromise on spending that the vast majority of members in this House can support. That requires realistic funding levels and elimination of partisan riders from this package. The spending package before us today may be a worthy starting point, but it will take hard work and compromise to move the final bill that can become law. With that, Mr. Speaker, I urge opposition to the rule, and I reserve the balance of my time.
Gentleman from Oklahoma reserves. Gentleman from Maryland is recognized.
Mr. Speaker, thank you very much. I'm delighted to hear from my friend from Oklahoma about both of these bills. We were here together last night until around midnight, working on the rules for these bills on HR 2740, the appropriations package that we've got together. We have authorized more than 100, I think it's the number's 112 bipartisan amendments. In fact, I think the first amendment is the one that is from the gentleman from Oklahoma. We've made that first. I won't be voting for it. I won't be supporting it, but he's got the opportunity to make his case on the floor of the House of Representatives. And and to present it to colleagues. And so we're proud of the fact that there are more than 100 amendments. In fact, I think we're meeting again this afternoon, and we might adopt dozens more amendments for the consideration of the full House. But on the question of H.R. 430, which is to empower the Judiciary Committee and the other committees in Congress to enforce our right to obtain information that we seek, I think that this should be an overriding bipartisan commitment within the Article I branch, within the Congress of the United States. We simply cannot tolerate a posture from the President of the United States. And it's hard for me to think of any other Congress that would tolerate it from any other president, of non-cooperation, absolute, comprehensive, wholesale defiance of the will of Congress in trying to seek information. My good friend from Oklahoma says that the president does not work to enforce the laws of Congress. He works for the people. Well, we all work for the people. That was my point. His job is to take care that the laws passed by Congress are faithfully executed, and we work directly for the people. At least until we get a national popular vote for the president is not elected by the people, as we know from the 2016 election itself, where the popular vote winner, who gained several million more votes than Donald Trump did, lost the election because of the workings of the Electoral College. The presidency was set up as an indirect mechanism, and that's something that I think that we should be replacing. But I think it's not appropriate to claim a popular mandate for the president when the president emerges from the Electoral College. In any event, the president's job is to take care that the laws are faithfully executed, also to be the commander-in-chief in times of actual conflict, but it is up to Congress to legislate. That's what we do. That's why it's so problematic when the President of the United States says, I will not accept bipartisan congressional rejection of billions of dollars in funding for my border wall. I'm going to declare a national emergency and then reprogram money from other lawfully appropriated purposes. That is a violation of the spending power of the Congress of the United States. It's just like the president rejecting a bipartisan repudiation of his involvement with the Saudi government in the Yemeni civil war. We have not declared war with Saudi Arabia against Iran or anybody else in the Yemeni conflict. And so we don't want to be involved in it. We don't want our money going to that bloody humanitarian catastrophe. And yet the president simply rejects the majority will of both houses of Congress. That is a decisive rejection and defiance of Congress's power to declare war. And now what we're getting is this complete defiance of our ability to get the information that we need. And the president said it very clearly. You know, he basically said, no subpoenas, no witnesses, enough, no do-overs. So he's not going to allow us to investigate the compromised security clearance process in the White House. He's not going to allow us to investigate the completely suspect corruption and distortion of the constitutional mandate for a census, which we've got to do by virtue of the Constitution every 10 years. And he's not going to cooperate with any investigation into the matters that were covered by Special Counsel Mueller, either the organized, systematic, comprehensive, sweeping attack on our elections by the GRU and Russian agents, or the more than 100 contacts they had with the Trump campaign, or the 10 different episodes of presidential obstruction of justice that were set forth by Special Counsel Mueller in his report. Well, we can't accept that. And so this legislation in H.R. 430 will give us the opportunity to go to court right away to enforce our subpoenas against this unprecedented defiance of congressional power by the President of the United States. And with that, I'll reserve the remainder of my time.
Gentleman from Maryland reserves. Gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker. I'd like to yield 2 minutes to my colleague from the great state of Oklahoma, Mr. Hearn.
Gentleman from Oklahoma is recognized.
Mr. Speaker, I thank my friend and colleague from Oklahoma, and Mr. Speaker, I thank my friend from Maryland, and remind us of the constitutional elected, that our president was elected by the way our Constitution describes and outlines, and we thank our president for the work he's doing. Mr. Speaker, I co-sponsored an amendment with Congressman Cole to remove a dangerous poison pill in the appropriations bill that would block the free exercise of civil rights for the American people. Congress has long supported our robust protections of rights of conscience. The right to follow your conscience on deeply held religious and moral beliefs is a foundational value of our country. In a free society like ours, adherence to one's convictions should not be just tolerated, but encouraged. Our forefathers fought like hell to liberate our country from a monarchy that mandated what to believe and how to behave. How soon we have forgotten. It happens in small increments, with minor changes here and there, but they grow larger and more invasive. Someday you'll find yourself back under the yoke with an oppressive government telling you what to believe and how to behave. This conscious rule is absolutely necessary to preserve the freedom of expression that we hold dear in our great country. The rider in the labor HHS bill eliminating this rule is a poison pill that does not belong in the appropriations package. The Trump administration has vigorously supported the right of our people to act on their religious and moral convictions. President Trump's leadership on this issue has encouraged millions of Americans who have seen these protections start to slip away in the past decade. Who are we to force people to act against their conviction and religious beliefs? It's a slippery slope to despotism, but I think some of my colleagues would have us go down that road in pursuit of some greater good. I can assure you that forcing American people to work against their convictions and beliefs will lead us to nothing but destruction. And I guarantee that this bill will never be signed into law if this language remains. This amendment must be made in order so that we can debate it and remove the poison pill from the final bill. Otherwise, the time my colleagues have spent on the labor HHS bill is a giant waste of time because it will never make it to the president's desk. Thank you, and I yield back to Mr. Cole.
Gentleman from Oklahoma reserves. Gentleman from Maryland is recognized.
Thank you, Mr. Speaker. All of us, of course, embrace and uphold the First Amendment and the rights of religious freedom, the right to not have government establish a religion and to participate in the free exercise of religion and to worship or to not worship exactly as you please. There's nothing in any of our legislation that would interfere with anybody's right to exercise precisely their religious preference, to worship exactly as they please, to belong to whatever religious faith or denomination they want. Now, I'm not quite sure exactly what the gentleman was referring to. We know that the idea of a religious freedom to discriminate has been asserted ever since the 1960s with the Civil Rights Act of 1964, where the hotel and motel and lunch counter and department store owners said that they had a religious right to only serve the customers that they wanted, and that maybe it violated their religious faith to have interracial parties seated in restaurants or at the lunch counter. Our Supreme Court rejected that. This Congress has rejected that. There have been similar efforts to say, we have a constitutional right not to serve gay and lesbian customers. That has been rejected, and I hope that this Congress will also reject it. We passed the Equality Act very proudly to add protection for LGBT people to the Civil Rights Act of 1964, and I hope that the Senate will go along with it. In any event, there's nothing in any of the legislation before us, and none has been cited, which violates any of the free exercise rights of the people. So, with that, unless I hear anything further, I'm just not moved by how anybody is affected by this appropriation negatively. My good friend, my other good friend from Oklahoma, that referenced the phrase checks and balances, and that does appear in the Federalist Papers. I think it's in Federalist 51. It actually refers to the relationship between the House and the Senate. That was the design of the framers of the Constitution, that the House and the Senate would check and balance each other. But the framers were very clear that we were overthrowing monarchy. We didn't want monarchy. That's why we got rid of the king. The revolutionaries and the rebels who gave us America, who wrote the Constitution, were trying to institute a new form of government representing we the people. That's why we are so proud to be able to serve in the people's house here. along with our friends in the Senate. But the president's core job is just to take care that our laws are faithfully executed. We have no kings here. We have no monarchs here. That's why we have the emoluments clause in the Constitution, which says that none of us who serves in Washington can accept any present, any emolument, which just means a payment, any office or title from a prince, a king, or a foreign government without the consent of Congress. And that is a cardinal principle in the Constitution. It's our original anti-corruption principle because the framers did not want the president or members of Congress selling out the country. They wanted complete undivided loyalty by those of us who come to Washington, who aspire and attain to public office, to have complete undivided loyalty to the American people and not to lobbyists for foreign governments and agents and saboteurs. So that's another real problem that this president seems not to recognize. That provision obligates him whenever he receives any money from a foreign government through his hotel or his office towers or any of his going businesses that he's kept going in the course of his tenure. Whenever he receives any of that money, he's got to come to Congress to ask for our permission, for our consent. We can show you records from lots of prior presidents who came to Congress to ask for consent because they received a Persian rug or a shawl or cufflinks. And yet, at least according to court reports and media reports, this president has been receiving hundreds of thousands of dollars or millions of dollars from foreign governments. In fact, the president, I think, made a voluntary deposit, he said, of the profits from foreign government receipts of $350,000 to the U.S. Treasury without any accounting to us, without any receipts, and without asking for our consent. So even if the Constitution said that you can't accept the profits from foreign payments, which it doesn't, it says you can't accept foreign payments, that would be insufficient because Congress has got to offer its consent. So look, we need to lay down the law about all of these matters. When we ask for a document, we want the document. When we issue a subpoena from the United States Congress, you comply with the subpoena. When we ask for a witness, the witness arrives. And that's what H.R. 430 is all about. We've got to empower Congress to enforce its will. And I reserve the remainder of my time.
Gentleman from Maryland reserves. The gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker. I yield 2 minutes to my good friend, the distinguished gentleman from New Jersey and most eloquent advocate for life in this chamber, Mr. Smith.
Thank you.
Gentleman from New Jersey is recognized.
I rise in opposition to the rule. Earlier this year, Mr. Speaker, President Trump made it clear in a letter that he will veto any piece of legislation that undermines or nullifies any pro-life policy, regulation, or rule. The bill facilitated by this rule reverses several life-affirming pro-life policies, including conscience protection, Title X reform, the Protecting Life and Global Health Assistance, and more. No one, Mr. Speaker, including doctors, nurses, and LPNs, and no entity like a hospital or health insurance plan should ever be compelled against their will into performing, facilitating, or subsidizing abortion. The approach bill overturns the conscience protection rule. Second, in late February, HHS promulgated the Protect Life Rule to reassert portions of President Ronald Reagan's Title X rule, including ending co-location of abortion clinics with family planning clinics subsidized by Title X. And 2740, the underlying bill, repeals and bans future promulgation by any president of the Protecting Life and Global Health Assistance, a significant reiteration and expansion of President Reagan's Mexico City policy, a policy designed to ensure that U.S. taxpayers are not funding foreign NGOs that perform or promote abortion as a method of family planning. Mr. Speaker, why is this so important? Because women and children, both home and abroad, deserve better than the violence of abortion. The humanity of the unborn child is beyond doubt. Yet the pro-abortion movement, like some kind of modern-day flat earth society, continues to cling to outdated, indefensible arguments cloaked in euphemism. Even the seemingly benign word choice withers under scrutiny. Choice to do what? Dismember a baby? Take pills to starve a child to death and then forcibly expel her or him from the womb? Inject chemical poisons that kill the baby? At the end of the process, Mr. Speaker, important policies embedded in the approach bill will be signed into law, but they will be vetoed. This will be vetoed and sustained by this Congress if
Gentleman's time is
the
expired.
anti-life policy are included.
Gentleman from Oklahoma reserves. Gentleman from Maryland is recognized.
Mr. Speaker, thank you. I still have not heard a single instance offered of anybody whose religious freedoms under the Constitution of the United States are threatened by any of the legislation here. I do know that the ultimate logic of the argument that we just heard here is to support legislation like what was just passed in the state of Alabama. In Alabama today, please read an article in the Washington Post this morning, Mr. Speaker. In Alabama today, if this legislation is signed into law, a 15-year-old girl who is raped by her step-uncle not only would not be able to obtain an abortion, because there's no exception for rape or incest in the ban that the legislature just passed, but she would be compelled to have him involved in the raising of the child, because Alabama protects the paternity rights of the rapist. So it's one of only 2 states in the country where a rapist continues to have parenthood rights in a child. So get this straight. If what we're hearing is actually enacted into law, and I understand my colleagues to be encouraging legislation like this around the country, like the law in Alabama, we will have a situation where girls who are 15 or 14 or 13 or 16 years old who are raped by their stepfathers or stepuncles must carry a child to term, have the baby, and in some states be forced to raise the baby with the rapist. Okay, so I don't think that's where we are today in America under Planned Parenthood versus Casey and Roe versus Wade. And certainly the majority is going to stand very strong for the health care for women and reproductive freedom for women and men to make their own decisions. With that, I'm going to yield 3 minutes to Ms. Sheila Jackson-Lee.
Gentlewoman from Texas is recognized for 3 minutes.
Thank the gentleman from Maryland, and I thank the speaker for his courtesies as well. There's a document that I hold in my hand that covers the epidemic, apparently, that is taking siege over America. It contains the Declaration of Independence and the Constitution of the United States. The Declaration of Independence, we paraphrase it, we all are created equal, with certain unalienable rights of life, liberty, and the pursuit of happiness. I'm honored to serve in this body and with honor walk through the halls and look at the historical depictions of the early years. Just coming back from D-Day in Normandy, I'm reminded of the brave men and certainly women who served in the United States military supporters in World War II, but the men who stormed the Normandy beach. And reminded, I'm sure, of the words of General Dwight D. Eisenhower, who said, "The world is watching, and they will join you in marching to victory." This Constitution has the 9th Amendment, the right to privacy. It has the right to freedom of religion and freedom of access and freedom of speech. And all that is being done here today is to acknowledge not only the poor 15-year-old, 13-year-old, and 14-year-old that my good friend from Maryland talked about, but all over the country denying poor women access to health services that should really be based upon their faith, their God, their family, and their medical provider. And some of the bills in Missouri, some of the bills that are being proposed, Georgia, Alabama, my own state of Texas, it is litigation that would get you health care. It is no respect of the individual human being, the person who may have to go back to the antics of yesteryear, dealing with the tactics of coat hangers that many of us are aware of. Let me also say that underlying in this rule is the opportunity for the force of the authority of the Article I Congress to enforce individuals to come before congressional committees such as the judiciary, of which we'll debate later. It is invested in this Constitution because Article I authority and the collegiate response that the founding fathers wanted us to have, that there are no unequal branches, there is a number one branch, and one branch should not ignore and disrespect the other branch. And therefore, if Article 1 branch, which we're in, asks for witnesses and them to be blocked by another branch that has no greater status, read the Constitution. So in this rule, we have tried to correct the imbalance and inappropriateness that is occurring in this body and in this process. And so I ask my colleagues to support the rule and the underlying legislation to restore the Constitution. I yield back.
Gentleman from Maryland reserves. Gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker. I yield 1 minute to my good friend, distinguished gentleman from Ohio, Mr. Gonzalez.
Gentleman from Ohio is recognized.
Thank you to the gentleman from Oklahoma for yielding. Mr. Chair, I rise today in opposition to the rule that would provide for consideration of H.R. 2740. This package provides funding for several items that would benefit my district in Northeast Ohio, but it falls short in several key regards, including funding for key programs that would help keep our children safe. In particular, Mr. Speaker, this package fails to provide adequate funding for the School Safety National Activities Program, which gives grants to schools to support safe learning environments, including programs to combat substance abuse and cultivate academic success. This bill provides $80 million less in funding than what the administration requested. I offered an amendment to raise that number by $10 million, but my colleagues in the majority blocked it from consideration. I think we can all agree that school safety is of the utmost importance and an area that is vital for Congress to invest in. I hope my colleagues on both sides of the aisle will work with me to assure that programs to protect our children, like the School Safety National Activities Program, remain a congressional priority. Thank you, and I yield back the balance of my time.
Gentleman from Oklahoma reserves. Gentleman from Maryland is recognized.
Mr. Speaker, actually, I'll reserve too.
Gentleman from Maryland reserves. Gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker. I yield my good friend from Pennsylvania 2 minutes.
Gentleman from Pennsylvania is recognized.
Thank you. I thank my friend from Oklahoma for yielding. Mr. Speaker, I rise today to strongly oppose the rule and spending package being debated before us. Not only does this massive spending package blow our budget caps by nearly $200 billion, but this flawed legislation severely undermines critical protections for the lives of the unborn. I'm very proud of the work that the Trump administration has been doing to finally make Title X about family planning and not a way of using taxpayer money to fund abortions. The administration's new Title X provisions draw a bright line between abortion and family planning, while ensuring taxpayer dollars are put towards comprehensive, preventive, and primary care for women. These new regulations will also make it easier for faith-based clinics to provide care through the Title X program, which will expand access to care for families. Yet, under this partisan piece of legislation, these protections are stripped and taxpayer funding for abortion clinics is increased. This is unacceptable. The fight to give a voice to the unborn will not be swayed by partisan poison pills. I urge my colleagues to oppose this rule and the underlying bill. With that, I yield back.
Gentleman from Oklahoma reserves. Gentleman from Maryland is recognized.
Mr. Speaker, I don't know if my friend from Oklahoma has any further speakers. I'm prepared to close if he wants to go.
Speaker, so I'd like to continue if we may, Mr.
Gentleman from Maryland reserves.
I'll reserve.
Gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker. I yield myself such time as I may consume. If we defeat the previous question, I will offer an amendment to the rule immediately to bring up H.R. 3056 for consideration under an open rule. The bill provides $4.5 billion of funding to address the immediate humanitarian crisis on the southern border. This is a crisis of significant proportions, Mr. Speaker. Our facilities for holding new arrivals, particularly children and the vulnerable, unaccompanied minors, are already at the breaking point. Simply put, we need more resources, and we need them today. This is not the first time we've needed to provide supplemental appropriations for this purpose. Back in 2014, then President Barack Obama asked us for $3.7 billion in supplemental resources for precisely the same purpose. He got it. And at the time, we had 60,000 unaccompanied minors that arrived in 2014. We face a similar, frankly, larger humanitarian crisis today. President Obama was right to request supplemental funds to deal with the crisis then. We would be right to appropriate supplemental funds to address that similar crisis now. So, Mr. Speaker, I ask unanimous consent to insert the text of my amendment in the record along with extraneous material immediately prior to the vote on the previous question.
Without objection.
Mr. Speaker, I would like to yield 2 minutes to my good friend, distinguished gentleman from Alabama, Mr. Rogers.
Gentleman from Alabama is recognized.
Thank you, Mr. Speaker, and I thank the ranking member. I rise in strong opposition to this rule. The rule demonstrates once again that the Democrat majority refuses to acknowledge, accept, or address the very real crisis at our southern border. New numbers recently came out illustrating the magnitude of the crisis. CBP detained more than 144,000 migrants in the month of May. This was the third consecutive month where we had in excess of 100,000 migrants detained at the border. 101,000 in March, 109,000 in April, 44,000 in May. We are on track to apprehend over 1 million migrants this fiscal year, approximately the population of Austin, Texas. Smugglers and cartels continue to preach that now is the time to come to the United States. They call children permisos, or permits, and exploit them to get scores of adults unrelated to the children across the border. These criminal organizations run an international smuggling operation filled with misery and abuse. Migrants that survive the smugglers often arrive in poor health, physically exhausted, and in need of urgent medical care. The men and women of CBP are doing the best they can to respond to this humanitarian crisis, but they have run out of space to safely house and process the unprecedented numbers of family units seeking entry into the United States. In the next couple of weeks, Health and Human Services will run out of funds to feed and shelter the vulnerable unaccompanied children. 4 weeks ago, the President and Congress sent an urgent request for supplemental appropriations to address this crisis. Ranking Member Granger and I filed an amendment with the minibus, which would have provided $4.5 billion requested by the President. It would have replenished critical funds needed to feed and shelter migrant families and unaccompanied children. It would have provided urgent medical care and transportation services, and it would pay the growing cost of overtime for the men and women of DHS working on the front lines of this crisis. Unfortunately, for the third time in the last month, the majority refused to make our amendment in order. Democrats haven't approved a dime for this crisis.
Gentleman's time has expired.
Yield the gentleman an additional 30 seconds, Mr. Speaker.
Gentleman's recognized.
Thank you. Because of the political dysfunction in their own caucus, they stubbornly refuse to put forward any solutions. It has gotten to the point where editorial boards in some of the nation's most liberal cities are now calling Democrats out for their inaction. Democrats need to stop denying the facts and blaming the president for this crisis. The time has come to face reality and work with the president and Republicans in Congress to immediately resolve this humanitarian crisis. I urge all members to defeat the previous question on this rule. If we do that, we can finally bring this critically needed supplemental funding to the House for a vote. With that, I yield back.
Gentleman from Oklahoma reserves. The gentleman from Maryland is recognized.
I'll reserve and am prepared to close if my friend is.
Gentleman from Maryland reserves. Gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker. I yield myself such time as I may consume. Mr. Speaker, my friend made reference a little bit earlier to amendments, and he talked about the total number of amendments, but he left out the distribution of amendments. So as the House considers this rule, I think we ought to take a look at how the Rules Committee has handled making amendments in order so far this Congress. The rule on the floor today is making 106 amendments in order out of 540 submitted, with hopefully more to come with tomorrow's rule. Today's rule includes 22 amendments sponsored solely by Republicans. Sadly, this is considered an improvement over the majority's previous efforts. With today's rule, in total, this Congress, 73% of all amendments made in order have been sponsored solely by Democrats. 73%. Just 16% are sponsored by Republicans, with 11% bipartisan. How does this compare with the last Congress? When Republicans were the majority party, 45% of all amendments made in order were sponsored solely by Democrats. Only 38% were sponsored solely by Republicans, with another 17% being bipartisan. At the beginning of this Congress, the Democratic majority repeatedly promised a new, robust, and open process at the Rules Committee. They pledged that good ideas would be welcome no matter where they came from, and that thoughtful amendments would not be blocked. Unfortunately, they have a long way to go to keep that promise. I think the numbers speak volumes. We are 5 months into the 116th Congress. Should we expect this trend of shutting out minority party ideas to continue? Should we expect the same course of action in our rule tomorrow, and in our rule on the second appropriations package next week, and in other rules in the weeks and months to come? When will the promises made by the Democratic majority be kept? If not now, when? With that, Mr. Speaker, I reserve the balance of my time.
Gentleman from Oklahoma reserved. Gentleman from Maryland is recognized.
And I'm prepared to close if the gentleman is prepared to close.
Gentleman from Maryland reserves. Gentleman from Oklahoma is recognized.
Thank you very much, Mr. Speaker. And I thank my friend. I'm also prepared to close. Mr. Speaker, in closing, I urge opposition to the rule. The rule will make in order two measures, Res 430 and HR 2740. House Resolution 430 is a premature and ineffective resolution that will push the House forward into an untested and ill-timed litigation with the executive branch over subpoena of documents. While the House has an important oversight role to play, we must be careful to exercise that role wisely and carefully, lest we cause long-term damage to the institution. HR 2740, a package of 5 of the 12 outstanding appropriations bills that use unrealistic allocation levels and eliminate long-standing pro-life protections that must be restored before these bills can garner any Republican support. I actually look forward to working with my colleagues in the House and the Senate as we move forward in the appropriations process. And I urge the majority to compromise with the Senate and the White House in order to achieve a final spending deal that avoids drastic sequestration cuts or, worse yet, another government shutdown. I think that's actually the great lesson of the appropriations process, Mr. Speaker. We know we can do this. We did it last year and did it pretty well together. But my friends have got to get past the idea that they can impose their will on a Republican Senate and a Republican president. They're simply not going to be able to do that. They're going to have to bargain to a middle ground and compromise. And the Appropriations Committee, as a rule, we do that. We do it pretty well. And I'm hopeful that we can continue going forward on that front. I am concerned, however, that the vitriol, if you will, that we see in the investigative and oversight efforts of our friends will spill into that process and lead us into a very difficult situation in September. So as we move forward on the appropriations front, again, I hope all of us relearn the virtues of compromise, understand that we were all sent here by the American people, that we have to work with one another to accomplish something, that none of us can impose our will on the other. And with that, I look forward to working with my friend and with his colleagues, and certainly through the appropriations process to making sure that the government is appropriately funded and well governed. And with that, Mr. Speaker, I yield back the balance of my time.
Gentleman from Oklahoma yields, and the gentleman from Maryland is recognized.
Mr. Speaker, thank you very much. And it's a pleasure to work with my friend from Oklahoma on HR 2740 and HR 430. And I do urge all of our colleagues to support this rule for this legislation. I do hope my friend from Oklahoma will tutor some of his colleagues, like the last speaker who referred to the Democrat majority. Democrat is the noun, Democratic is the adjective for our party. And I think that would be a basic gesture of inter-party civility if they would follow that fairly easy grammatical device. Mr. Speaker, one of the other members from the other side, I think from Oklahoma, talked about some education matters. So I want to go to some statistics that actually mean something to the American people. I think we can refute all of the statistics that were advanced by my friend from Oklahoma. As I said, there are more than 100 amendments that we're going to be bringing up today, and we're going to be adding more of them. And we certainly don't want to endure lectures from people who belong to the caucus that ran the most closed Congress in the history of the United States. But here are some figures that actually mean something to the American people. Our bill provides a total of $75.9 billion in appropriations for the Education Department, which is $4.5 billion above the 2019 enacted level and $11.9 billion beyond what the president asked for. So that means dramatic increases in everything from IDEA special education spending to education, innovation, and research programs to spending for teacher professional development, evidence-based models, and so on. We're also increasing money for student financial assistance, for Pell Grants, for higher education, because it's become too difficult for our young people to make their way through college, and they're graduating basically with a mortgage of $100,000 or $150,000, but they don't have a house to go with it. So this majority is committed to alleviating the burden on America's college students. Mr. Speaker, we are trying to make progress under very difficult circumstances with this president for the American people in the realm of education, healthcare, scientific and medical research. We're making that progress, and we urge all of our colleagues to support this legislation. I urge a yes vote on the rule and the previous question. I yield back the balance of my time, and I move the previous question on the resolution.
The question is on ordering the previous question on the resolution. Those in favor say aye. Those opposed, no. In the opinion of the chair, the ayes have it.
Mr. Speaker, on
Gentleman
that,
from
I would
Oklahoma
like
is
to
recognized.
request the yeas and nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. Pursuant to Clause 9 of Rule 20, this 15-minute vote on ordering the previous question will be followed by 5-minute votes on adoption of the resolution, if ordered, and agreeing to the Speaker's approval of the journal, if ordered. This is a 15-minute vote.
For the past hour, the House has been debating the rule for a couple of significant measures. The first is the 4 initial spending bills for fiscal year 2020. We heard some discussion about appropriations in the last hour of debate. The second is the resolution, HRES 430, the resolution that would empower House committee chairs to subpoena Trump administration officials. And joining us to help understand what the House will be debating and voting on later on today is Andrew Desiderio, who covers the House for Politico. Let's start specifically on the subpoena for the Attorney General, William Barr, and Don McGahn. What are they hoping to get out of this action in the House?
So what this action will allow them to do is it allows Jerry Nadler, the chairman of the Judiciary Committee, to essentially go to federal court and try to enforce this subpoena, because on the Justice Department front, Attorney General Barr has refused to turn over the full unredacted Mueller report. And then on the Don McGahn side of things, of course, the former White House counsel has refused to even show up to testify or to give documents to the committee. So this resolution represents a broad expansion of power, not just for Chairman Nadler on the Judiciary Committee, but for all committee chairs to essentially sue the Trump administration, sue witnesses, sue companies and entities that defy congressional subpoenas.
The House is going ahead with this, even though yesterday the Department of Justice agreed to release initially, or make available initially, some additional material from the Mueller report. Why is the House continuing anyway?
So what today's vote represents is it's a civil contempt vote. Yesterday, what Chairman Nadler was referring to was criminal contempt. Criminal contempt is much more difficult to secure against the Justice Department because it would essentially involve the Justice Department charging the sitting Attorney General with a crime. That's essentially never going to happen. But it's definitely something that Democrats want to leave on the table, rather, as they pursue all of these documents. But what today's vote is really about is to seek civil enforcement of that subpoena so that the chairman and the House General Counsel can immediately go to federal court, really whenever they want to seek this information.
And you pointed this out. I think there's some 6 committees in total that are sponsoring this resolution. In fact, we may hear more about this tomorrow in the Oversight Committee, I understand, from Elijah Cummings. What can you tell us about that?
Right. So the Oversight Committee is set to hold the Attorney General in contempt again, and they're also going to hold the Commerce Secretary, Wilbur Ross, in contempt over their refusal to turn over documents and to provide witnesses for the committee's investigation into how a citizenship question got added to the 2020 census. This came to a head last week when the committee set a deadline of Thursday at 5 p.m. To essentially comply with that subpoena before they move forward with contempt. The important thing about what they're voting on today is it allows Chairman Cummings in the Oversight Committee and any other committee chairs to go to court to enforce subpoenas that have either already been issued or have not yet been issued. For example, if another committee issues a subpoena for a different matter 2 months from now, this resolution allows that committee chairman or chairwoman to go to court and sue the Trump administration to enforce that subpoena in court and get the documents or witness testimony that they're seeking.
And what sort of issues would it have presented to the Judiciary Committee, the House broader House Democrats, if the Democrats had chosen to go in the direction of issuing a contempt citation against the Attorney General?
So it's really difficult to do that because essentially you're referring it to the U.S. Attorney in D.C., which is under the control of the Justice Department. It's very unlikely, in fact, probably impossible under this Justice Department, that they would charge their sitting Attorney General. But the thing that Attorney General Barr has to be concerned about is having this essentially black mark on his record of a criminal contempt citation against him, even though it would be essentially toothless in that they wouldn't be able to prosecute it and they wouldn't want to prosecute it, that is the Justice Department. It's not something that he would want to have on his record necessarily. So they're going to try to do anything they can to avoid a criminal contempt citation, which I think is why the Justice Department yesterday reached that deal with the Judiciary Committee to try to provide at least some documents from Special Counsel Mueller's files.
So the Department of Justice already agreed to additional material, but if this passes, this resolution passes the House, this says, okay, we can now subpoena the Attorney General, sue him in federal court for the entire unredacted Mueller report, correct?
Right. That's exactly what it allows them to do. But as of now, Chairman Nadler is probably going to hold off on that while this document production is rolling. They called it yesterday a rolling document production, meaning they won't get everything at once, but they're still negotiating at this point for specific documents they might want and allowing members of the Judiciary Committee to head over to the Justice Department and view these documents. So essentially, it's in his back pocket.
You and your Politico colleagues, Heather Cagle and John Bresnahan, with a piece today over the headline says clash between Jerry Nadler and Nancy Pelosi over impeachment. What is that clash all about?
So we've reported that behind the scenes, Chairman Nadler has essentially been making the case to Speaker Pelosi as to why an impeachment inquiry would help his committee as they try to obtain documents and secure different witness testimony. He's only made that argument behind the scenes because he worries sort of about the politics of going against Speaker Pelosi in this moment. But it's something that they have been clashing about behind the scenes. It's not a particularly contentious clash because these two have been longtime allies for decades now. They worked together during the Clinton impeachment, of course, and Speaker Pelosi has long supported Chairman Nadler's efforts to issue subpoenas and to conduct the committee essentially the way he wants it to be conducted. And that's something that, allies of both Speaker Pelosi and Chairman Nadler have been stressing at this point. But it is a real disagreement because you have 60 House Democrats right now who want to start an impeachment inquiry.
Well, and doesn't today's action, if the House passes this resolution, make it easier for the Trump administration? Let's say a subpoena is issued, they're sued in court, and they still defy it. A federal judge orders the administration to do something. That gives possible grounds for impeachment?
That is something that I have heard specific members of Congress mention, actually, who are not yet in the impeachment camp. They're saying, look, if it comes to the point where the president is issued a court order to comply with something and he still does not comply, at that point, that member would say, hey, I support opening an impeachment inquiry right now. But we're not sure how soon that could come. Some of these court cases are being decided throughout the summer. Others could lag into the fall and even the winter. So the timeline is still very uncertain.
Lastly, where do you think, if this resolution passes, what do you think the next steps are in terms of the judiciary investigation?
So the Judiciary Committee is going to focus not only on getting Don McGahn into the committee, of course, Mueller's central witness, but he's also, Chairman Nadler is also going to want to get Mueller himself in to testify. There's this talk right now about them potentially issuing a subpoena to compel Mueller's testimony. Mueller has indicated to the Judiciary Committee privately that he does not want to answer questions from lawmakers in public, but would rather do so behind closed doors. That's, of course, a non-starter for Democrats. So they might have to resort to a subpoena for Special Counsel Mueller in order to get him in front of the cameras.
Andrew Desiderio covering the House for Politico, Politico.com for the articles, and he's at Desiderio DC on Twitter. We'll keep our eye on that, too. Thanks so much.
Thanks, Bill. Appreciate it.
You bet.
Good to see
Absolutely.
you. Thanks.
First vote in a series here in the U.S. House. This is the previous question vote. Basically, Republicans here are seeking to amend the rule to bring up the issue of immigration at the southern border and the border security supplemental. This 15-minute vote is the previous question. They will vote on the rule for the resolution and for those, the rule covers also those appropriations bills for fiscal year 2020. But we'll see more debate ahead coming up, general debate on the resolution within the hour or so. And as this vote continues, we'll bring you some of the debate on the floor that just wrapped up.
House Resolution 430, Mr. Speaker, comes from a dispute over documents relating to the special counsel's investigation into Russian interference in the 2016 presidential election. The dispute also stems from the inherent oversight authority Congress and our ability to perform oversight functions over the executive branch. And it falls into the fuzzy boundaries between the branches of government. When and how we may compel the executive branch to turn over documents to the legislative branch. I lay out that framework because there's an important point here that's being lost. The Democratic majority clearly wants to make this dispute entirely about this president, this attorney general, this White House counsel, this investigation, this subpoena of documents. The Democrats want to focus attention there because they think it helps them politically to do so. But this dispute really shouldn't be about just that. It should rather be about the difficult and thorny questions that emerge in a system like ours with three branches of government with checks and balances. In a sense, what the majority is seeking to do here today is completely unprecedented, both in its intent and in its execution. Consider the only other times the House has filed a lawsuit to seek to enforce a subpoena for documents. It's happened twice before, Mr. Speaker, once in 2007 to seek documents from the former White House counsel Harriet Miers, and again in 2012 to seek documents from then Attorney General Eric Holder as a result of the congressional investigation into the Fast and Furious scandal. In both of these cases, the House had already voted to hold both Miers and Holder in contempt of Congress before filing suit, which has not yet happened in this case. In the Miers case, 138 days elapsed from the first document request to the Judiciary Committee voting to hold her in contempt. In the Holder case, it was significantly longer. 464 days elapsed from the first document request to the committee voting to hold him in contempt. That was well over a year. But here, the majority is forcing us to rush forward at a much faster pace. Just 44 days elapsed from the date of the first document request to the Attorney General until the Judiciary Committee voted to hold him in contempt. 44 days. James Holzhauer has been champion of Jeopardy for longer than that. I don't understand the majority's haste here. Without exhausting all other options, continuing negotiation, discussion, compromise, and turning to a vote on contempt as the last resort, the majority is instead pushing us forward into litigation with the executive branch. And in doing so, they may well be placing the House in a position that causes significant long-term damage to the institution. When this matter goes before the courts, it will do so as a case of first impression and under an untested legal theory. In both the Miers and Holder cases, the House previously voted to hold those two individuals in contempt of Congress. Nothing like that's been done here, and using untested tactics like this could set a dangerous precedent that harms us all, Republicans and Democrats, in the long run. Finally, I would also note that it's not clear what this resolution will ultimately accomplish. Since the House has not yet exercised all the tools in its toolkit, and since it's not clear that the negotiations with the Justice Department and the White House over the documents at issue is at an end, this whole thing may be nothing more than sound and fury. Indeed, given how quickly the majority is rushing into things, it seems unlikely that the only course of action left to the House is to file a lawsuit. I strongly urge the majority to continue working with the Justice Department and the White House to find a resolution to these issues without resorting to knee-jerk lawsuit that may ultimately damage the House as an institution.
But on the question of H.R. 430, which is to empower the Judiciary Committee and the other committees in Congress to enforce our right to obtain information that we seek, I think that this should be an overriding bipartisan commitment within the Article I branch, within the Congress of the United States. We simply cannot tolerate a posture from the President of the United States. And it's hard for me to think of any other Congress that would tolerate it from any other president, of non-cooperation absolute, comprehensive, wholesale defiance of the will of Congress in trying to seek information. My good friend from Oklahoma says that the president does not work to enforce the laws of Congress. He works for the people. Well, we all work for the people. That was my point. His job is to take care that the laws passed by Congress are faithfully executed, and we work directly for the people. At least until we get a national popular vote for the president is not elected by the people, as we know from the 2016 election itself, where the popular vote winner, who gained several million more votes than Donald Trump did, lost the election because of the workings of the Electoral College. The presidency was set up as an indirect mechanism, and that's something that I think that we should be replacing. But I think it's not appropriate to claim a popular mandate for the president when the president emerges from the Electoral College. In any event, the president's job is to take care that the laws are faithfully executed, also to be the commander-in-chief in times of actual conflict, but it is up to Congress to legislate. That's what we do. That's why it's so problematic when the president of the United States says, I will not accept bipartisan congressional rejection of billions of dollars in funding for my border wall. I'm going to declare a national emergency and then reprogram money from other lawfully appropriated purposes. That is a violation of the spending power of the Congress of the United States. It's just like the president rejecting a bipartisan repudiation of his involvement with the Saudi government in the Yemeni civil war. We have not declared war with Saudi Arabia against Iran or anybody else in the Yemeni conflict. And so we don't want to be involved in it. We don't want our money going to that bloody humanitarian catastrophe. And yet the president simply rejects the majority will of both houses of Congress. That is a decisive rejection and defiance of Congress's power to declare war. And now what we're getting is this complete defiance of our ability to get the information that we need. And the president said it very clearly. You know, he basically said, no subpoenas, no witnesses, enough, no do-overs. So he's not going to allow us to investigate the compromised security clearance process in the White House. He's not going to allow us to investigate the completely suspect corruption and distortion of the constitutional mandate for a census, which we've got to do by virtue of the Constitution every 10 years. And he's not going to cooperate with any investigation into the matters that were covered by Special Counsel Mueller, either the organized, systematic, comprehensive, sweeping attack on our elections by the GRU and Russian agents, or the more than 100 contacts they had with the Trump campaign, or the 10 different episodes of presidential obstruction of justice that were set forth by Special Counsel Mueller in his report. Well, we can't accept that. And so this legislation in H.R. 430 will give us the opportunity to go to court right away to enforce our subpoenas against this unprecedented defiance of congressional power by the President of the United States.
That is some of the floor debate, the rule debate on the measure today, the resolution coming up that would allow House Committee Chairman to enforce subpoenas issued to the administration. The first of 3 votes here on the House, or up to 3 votes anyway. This is the previous question. Republicans are seeking to amend the rule for it, bringing up the issue of immigration at the southern border and border security funding. The debate itself on the resolution, the House Resolution 430, will last an hour, provided it's passed here. The rule passes next. And we expect that Tom Cole, the ranking member of Rules, and also Jim McGovern, the chairman of the Rules Committee, will lead that debate, in that the resolution was introduced by James McGovern of Massachusetts, and along with the chairs of 6 House committees. And again, it would empower them to be able to subpoena and sue in federal court for documents and testimony from the Trump administration. This first vote is 15 minutes. The vote on the rule itself will be 5 minutes, and there's possibly one more vote after that, and then we will see that hour of general debate on the resolution. President Trump weighing in early again this morning on the Mueller report, and today's action on Capitol Hill, in the House anyway, and the president talking about what's going on. As he departed today, he's heading out to Iowa, to Council Bluffs, to talk about energy and to meet with campaign sponsors and supporters out there. President Trump earlier today at the White House.
The amazing thing is, all I do is get hit by this phony witch hunt, although they don't mention Russia anymore because there was no collusion. So now they want to try and say, well, did he obstruct a no collusion? So there was no crime. The crime was by the Democrats, folks. They've committed, in my opinion, many crimes, and time will tell what happens there. But the crime was by the Democrats. My poll numbers have been very, very good. We're starting really next week. It's going to be something, I think, very special. We're starting in Orlando, Florida. Excuse me? No, I'd rather run against, I think, Biden than anybody. I think he's the weakest mentally. And I like running against people that are weak mentally. I think Joe is the weakest up here. The other ones have much more energy. I don't agree with their policies. But I think Joe is a man who is, I call him 1% Joe, because until Obama came along, he didn't do very well. But look, but I don't bring him up. The best thing that ever happened to the farmers is me. We gave $16 billion to the farmers to make up for the deficit with China. We gave them $16 billion. We don't give them it, they earn it because they're patriots. We gave them ethanol at 15, which nobody was ever going to do, which Biden didn't do in 8 years as, vice president. The farmers are my best friend. Nobody has treated the farmers better than Donald Trump.
Do you have an agreement with Mexico to become a safe third country for asylum seekers?
That's the agreement that everybody says I don't have. So, no, because I'm going to let Mexico do the announcement at the right time. From Mexico, they want to go through, but here's the agreement. It's a very simple agreement. This is one page. This is one page of a very long and very good agreement for both Mexico and the United States. Without the tariffs, we would have had nothing. We had nothing 2 weeks ago. Mexico told us absolutely, I don't know where the Times got the story, but I think they got it probably for somebody that worked here and said, oh, how well they would do. Well, for a long time, for many years, people tried to get what we got in a period of a couple of days, and they couldn't get it. That's the difference. They couldn't get it. So Mexico, we're getting along with them great. Marcelo and the president and all of them, we're getting along great. They've started a very strong action. They're moving right now 6,000 soldiers to their southern border. Whoever heard of that? You think we had that 2 weeks ago? 2 weeks ago, I'll tell you what we had. We had nothing. And the reason we had nothing is because Mexico felt they didn't have to give us anything. I don't blame them. But this is actually ultimately going to be good for Mexico, too. And it's good for the relationship of Mexico with us. So here's your thing. They all say, oh, he does it. I just give you my word. Inside here, and I would love to do it, but you will freeze action it, you will stop it, you will analyze it, every single letter you'll see. But in here is the agreement.
And what's the agreement, sir?
President Speaker Pelosi said today that every time you attack her, her stock goes up. Are you helping her politically?
Now look, Nancy is a mess. The Democratic Party is a mess. They're doing everything they can to win the election in 2020. They are guilty of many crimes. Many crimes, what they've done. They're guilty of many crimes. And hopefully in a short period of time, that'll be seen. They should never have done what they've done. And all they do is waste time on these investigations where there's no obstruction, no collusion, no nothing. And in the meantime, they can't get a border deal done. They can't do anything. We need, in addition to the great deal with Mexico, we need them to work on illegal immigration, on lower drug prices, on infrastructure, and they're not doing anything. They've come to a halt.
Specific question, if I could. Did Mexico agree? Did Mexico agree? Sorry. Did Mexico agree in the negotiations last week to become a safe third country for asylum seekers?
I don't want to say, but you can just figure it out yourself right here. And the reason is Mexico wants to handle that, would have to go through their their legislative body.
But I heard that they agreed to that on Friday.
A lot of people heard they agreed to it. A lot of people are saying that. Good luck. Okay? I'm not going to say one way or the other, but I will tell you, right here is the story. You know, I don't like it when newspapers write fake news or when reporters like you do fake news. I don't like that. So right here is the agreement. It's very simple. It's right here. And in here is everything you want to talk about. Done. It's done. It's done. It's all done. Emerald.
Joe Biden, he reportedly would have changed his rhetoric about China to say, we need to get tough. They are a competition.
Joe Biden thought that China was not a competitor of ours. Joe Biden is a dummy. Joe Biden thought China was not a competitor. China made $500 billion over a short period of time against Obama, Biden, and for many, many years, in all fairness to them. China is a major competitor, and right now China wants to make a deal very badly. It's me right now that's holding up the deal. And we're going to either do a great deal with China or we're not doing a deal at all. Right now, China is paying us billions and billions of dollars. They never gave us 10 cents. And China ate our country alive during Obama and Biden. They ate us alive. And then Biden has some kind of a relationship financially, or his son, with China. Tell me about that. Because China ate the United States alive economically, and it's a shame.
So, Mr. President, how do you respond to the Democrats
No,
who say you're not
Pelosi attacked me. She was here. She made a horrible statement that I'm sure she wished she didn't make. She made a horrible statement while I was with the Queen of England, while I was with the President of France. And you're not supposed to do that, okay? But the ones that committed the crimes are the Democrats and others.
You were a Venezuela
deserve asylum in the U.S. Why haven't you?
We're looking at that, and we're very much involved with the Venezuela crisis. It's a horrible thing, a horrible situation. It's been brewing for many years. It really started in the worst form during the Biden-Obama administration, but it's been brewing for a long time. So we're looking at that very strongly. We're looking at it.
On Xi, your tweet about Xi and the threat of tariffs if he doesn't meet with you, where are you on that?
My relationship with President Xi of China is a very good one. One of the people I really like. I get along with him right. He's representing China. I'm representing the United States of America. We're doing very well. We're taking in billions and billions of dollars. Companies are leaving China right now, and they're coming here because they don't want to pay the tariffs, and they're going to other countries. But I think that China, I can tell you, China would like to make a deal very badly. They're getting hurt very badly by the tariffs because companies can't pay the tariffs, so they're leaving China. And the other thing you have to remember about China is that China will subsidize companies, so our taxpayer is not paying for very much of it. A report came out, they're paying for very little of it. But what it's doing is creating a fair playing field, which we've never had with China since the WTO, the World Trade Organization.
G20? Will you meet with Xi at the G20?
We expect to meet with President Xi very shortly. We think we'll meet him at the G20. We're talking, we have a very good relationship. Look, we had a deal with China, and then they went back on the deal. They said, we don't want to have 5 major points. So we changed it. But we had a deal with China. And unless they go back to that deal, I have no interest. Right now, we're taking in billions and billions of dollars. I've created something, what we've done in the last 2.5 years, we've picked up $14 trillion in net worth of the United States. And China's gone down probably by 20 trillion. There's a tremendous gap. When I came in, that gap was getting very close. Well, I love Iowa. I've gotten along great. I won Iowa by a lot the last time. Usually a Republican would not win it by that much, but I won Iowa, as you know, by a lot. I have a great relationship with the farmers. I have a great relationship with everybody. I mean, Iowa, I think, is going to be something that we win very easily. I think we're going to win. I saw a fake poll, a suppression poll in Pennsylvania. I even saw one in Texas. They're suppression. They're fake polls, just like the fake media, of which there are many here. They're fake polls. We're going to win Texas by a lot. We're going to win Iowa by a lot. We're going to win, I would say, every Pennsylvania. I think we're going to do very well. We have steel companies opening up that for 40 years they didn't open up steel companies. Now they're opening up. No, I think we're doing very well. So I see that, and I just received a beautiful letter from Kim Jong-un, and I think the relationship is very well, but I appreciated the letter. I saw the information about the CIA with respect to his brother or half-brother, and I would tell him that would not happen under my auspices. That's for sure. I wouldn't let that happen under my auspices. But I just received a beautiful letter from Kim Jong-un. I can't show you the letter, obviously, but it was a very personal, very warm, very nice letter. I appreciate it. And I'll say it again. I think that North Korea has tremendous potential, and he'll be there. I think that North Korea, under his leadership, but North Korea, because of what it represents, the people are great, the land is great, the location is incredible between Russia, China, and South Korea. I think North Korea has tremendous potential. And the one that feels that more than anybody is Kim Jong-un. He gets it. He totally gets it. But I don't know. I have not heard about that, but we'll see. I would, but I want to get it further advanced. In the meantime, no nuclear testing, no major missile testing, nothing like when I first got here. When I first got here, it was a bad mess. We have a very good relationship together. Now I can confirm it because of the letter I got yesterday. And I think, I think that something will happen that's going to be very positive. But in the meantime, we have our hostages back. The remains keep coming back. We have a relationship.
Would you address the Democrats?
Say it. I don't know anything about that. I know this, that the relationship is such that wouldn't happen under my auspices, but I don't know about that. Nobody knows.
So, Mr. President, could you address the Democrats?
Quiet.
Could you address
The border wouldn't be as bad today if they passed
say that you're lying.
That includes
Up a little higher.
Meckelina said that the border wouldn't be as bad if Congress had passed the 2013 immigration bill.
On this vote, the yeas are 227. The nays are 190. The previous question is ordered. The question is now on adoption of the resolution. All those in favor say aye. All those opposed say no. The ayes have it.
Mr. Speaker, I would request the yeas and nays.
The yeas and nays have been requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. This is a 5-minute vote.
And the House now moves on to a vote on the rule for debate for a resolution that would authorize the House Judiciary Committee Chair, Jerry Nadler, to seek civil action in federal court against the Attorney General, William Barr, and against former White House counsel, Don McGahn, specifically seeking the unredacted Mueller report from the Attorney General and public testimony from Mr. McGahn. What's more broadly, it reinforces the authority under House rules that the House committee chairs can go to federal court to seek civil enforcement of their subpoenas. It's done so under what's called the 5-member House Bipartisan Legal Advisory Group. This would authorize that group comprised of the Speaker, Majority Leader, the Majority Whip, the Minority Whip, and the Minority Leader, and that could happen without a vote in the full House. So they're voting on the rule for debate. That debate coming up shortly, if this rule passes, would be 1 hour. It will be led, we understand, by the Rules Committee Chair, Jim McGovern of Massachusetts, and Republican Tom Cole of Oklahoma, the ranking member on rules. The Rules Committee met yesterday to consider today's debate. Let's take a look at some of that from yesterday with Mr. Cole, Representative Cole, and Representative McGovern.
So this is really a sad day. We're here today because the President of the United States has shown an unprecedented and complete disregard for the rule of law, the separation of powers, and the constitutional oversight responsibilities of Congress. He's used every trick in the book to stonewall our oversight efforts at every turn, whether it's false claims of executive privilege, absolute immunity, or lack of legitimate legislative purpose. You don't have to take my word for it. President Trump himself has declared, and I quote, "We are fighting all subpoenas. I don't want people testifying and no do-overs," end quote. He sounds more like a mob boss than the President of the United States. His administration is unfortunately more than happy to follow his lead. Attorney General Barr refused to release the full, unredacted Mueller report and underlying evidence. That's why the House Judiciary Committee recently voted to hold him in contempt of Congress. There was news today that an agreement was reached on some of the underlying evidence, but it is yet to be seen whether the Department of Justice will live up to its side of the deal. So we need to keep all options on the table, not to mention that there are some documents and information that falls outside of this agreement. Meanwhile, former White House counsel Don McGahn has also failed to provide documents to Congress while refusing to testify before Congress. This unrelenting campaign of stonewalling doesn't stop with the Mueller report. It includes many issues that impact Americans' everyday lives. Issues like the president's attack on the affordable health care coverage, including those with pre-existing conditions, his family separation policy, his misappropriation of military funds for his offensive border wall, his attack on civil rights protections, and I could go on and on and on. The president's actions test the very notion the founders based our government upon. 3 separate but co-equal branches of government, each with unique powers and responsibilities, and each expected to act as a check on the power of the others. President Trump's strategy here is clear. Turn America into a place where the President of the United States isn't only immune from prosecution in the courts, but also immune to any congressional accountability. But here's the bottom line. Each and every member of Congress in this body took an oath of office, not to this president, not to this administration, but to the Constitution of the United States of America. Donald Trump might not care much about upholding his oath, but we care about upholding ours. We raised our right hand and swore to protect and defend the Constitution, and that is exactly what we are doing here today, just as our founders intended us to do. That is why we are here today to mark up H-Res 430, a resolution I introduced last week with the support of 6 committee chairs, Cummings, Engel, Nadler, Neal, Schiff, and Waters. The first part of this resolution authorizes the Judiciary Committee to seek civil enforcement of its subpoenas against the Attorney General, requiring him to provide Congress with the key evidence underlying the Mueller report, as well as the unredacted report itself. It would also enforce the committee's subpoenas of Don McGahn, requiring him to provide documents and appear for testimony. That follows past precedent used by Democratic and Republican majorities to conduct oversight. The second part of this resolution reaffirms key language in House rules, making clear that every committee chair retains the ability to go to the federal court to seek civil enforcement of their subpoenas authorized by the Bipartisan Legal Advisory Group. That includes subpoenas that are already issued as well as future subpoenas. This efficient approach will allow us to walk and chew gum at the same time, to hold the president accountable while continuing to deliver for the American people on other issues like healthcare, infrastructure, and jobs. Look, I wish we didn't have to be here today. I wish Donald Trump acted more like a president and less like a king. But this resolution is necessary because of his actions and those of his administration. If we don't stand up to President Trump, then Congress could lose its power to stand up to any president in the future. No member of Congress should sit idly by and let that happen. And this Democratic majority certainly isn't going to let it happen without a fight. And with that, I'm happy to turn the mic over to the ranking member, Mr. Cole, for any remarks he may have.
Thank you very much, Mr. Chairman. We're here today for an original jurisdiction markup for a bill that is quite frankly unprecedented. House Resolution 430 seeks to authorize the Committee on the Judiciary to initiate or intervene in judicial proceedings to affirm the duty of the Attorney General, William P. Barr, and the former White House counsel, Donald F. McGahn, to comply with certain subpoenas. This authorization extends to the petition for disclosure of grand jury material that otherwise may not be disclosed under law. I call the events under consideration today unprecedented because this sequence of events has literally never happened before. The House of Representatives has only filed lawsuits to demand documents twice, and both times the individuals in question were held in contempt of Congress prior to the House filing suit. That's not the case here. In neither of the previous cases did the House move with anything close to the speed at which the majority is pushing us forward today. Let's consider what happened in those two previous cases. In 2007, the House filed suit to recover documents from former White House counsel Harriet Miers. It was 138 days from the date of the first request until the Judiciary Committee voted to hold Miers in contempt of Congress. In 2012, the House voted to hold then Attorney General Eric Holder in contempt of Congress over his failure to turn over documents related to the Fast and Furious scandal. But it was 464 days from the date of the first request to the Judiciary Committee voting to hold Holder in contempt. 464 days. Here, just 44 days have elapsed from the date of the first document request to the Attorney General until the Judiciary Committee voted to hold him in contempt. The speed with which this matter is moving has never happened before. I don't understand the majority's haste here. Without exhausting all other options, negotiations.
The gentleman is not recognized for debate at this time. For what purpose does the gentleman from Massachusetts, Mr. McGovern, seek recognition?
Mr. Speaker, pursuant to House Resolution 431, I call up House Resolution 430 and ask for its immediate consideration.
The clerk will report the title of the resolution.
House Calendar Number 27, House Resolution 430, resolution authorizing the Committee on the Judiciary to initiate or intervene in judicial proceedings to enforce certain subpoenas and for other purposes.
Pursuant to House Resolution 431, the amendment in the nature of a substitute recommended by the Committee on Rules printed in the resolution is adopted, and the resolution as amended is considered read. The resolution as amended shall be debatable for 1 hour, equally divided and controlled by the chair and the ranking minority member of the Committee on Rules. The gentleman from Massachusetts, Mr. McGovern, and the gentlewoman from Arizona, Ms. Lesko, each will control 30 minutes. The chair now recognizes the gentleman from Massachusetts, Mr. McGovern.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days in which to revise and extend their remarks and insert extraneous material on HRes 430.
Without objection.
And Mr. Speaker,
the House shall come to order. The gentleman may proceed.
Mr. Speaker, I yield myself such time as I may consume.
Gentleman is recognized.
Mr. Speaker, this is a dark time. This Congress is being tested, in this case, not by a foreign adversary, but by our own president. A president who is undertaking a relentless campaign of obstruction and stonewalling. We have never seen anything like this. Never before, Mr. Speaker, has a president of either party so flagrantly ignored Congress's constitutional oversight authority and our nation's separation of powers. You don't have to take my word for it. President Trump has declared, quote, "We are fighting all subpoenas, and I don't want people testifying," end quote. These words make Richard Nixon look like an Eagle Scout. His Attorney General, William Barr, is apparently more than willing to follow the president's command. He has refused to release the full unredacted Mueller report and the underlying evidence until a compromise was finally reached yesterday. That's after the Judiciary Committee had already voted to hold him in contempt of Congress. Apparently, the Attorney General went from being America's lawyer to being the defense counsel for the President of the United States. I hope the Justice Department acts in good faith on this new agreement. These are documents that Congress needs to see in response to Special Counsel Mueller's findings. But if they do not, and if the Attorney General holds back key information, then all options need to be on the table, including enforcing these subpoenas. That's in addition to the fact that some documents and testimony we deserve to obtain could very well fall outside the bounds of this agreement. And the Mueller report is just the tip of the iceberg. The president is using every trick in the book, including false claims of executive privilege, absolute immunity, and lack of legitimate legislative purpose, all to obstruct legitimate inquiries into matters that impact Americans' daily lives. This includes the president's attack on the affordable health care coverage for millions of Americans, including those with pre-existing conditions, his family separation policy that has torn apart vulnerable immigrant families, his misappropriation of military funds for his offensive border wall, and his decision to roll back landmark civil rights protections. This is exactly the sort of concentrated power in the hands of the few that the founders intentionally prevented through the creation of the three separate but co-equal branches of government. Each branch with unique powers and responsibilities, and each branch expected to act as a check on the power of the others. But the president is trying to take this balance of power and centralize it in one place, 1600 Pennsylvania Avenue. He's acting as though the law applies to every American but himself. The president's strategy here is clear. Tweet by tweet, quote by quote, he's laid it bare for all of us to see. The question is whether this Congress will have the courage to take a stand against it, whether we will confront this for what it is, an attack on the very notion of Congress as a co-equal branch of government. Now, I can't speak for my friends on the other side of the aisle, but this Democratic majority will not allow this president to turn a blind eye to the rule of law. And that's why I introduced this measure, H-Res 430. It is a civil enforcement resolution that will strengthen our hand in court as Congress tries to get the documents this administration is currently trying to hide. So if we can uncover the truth and follow the facts wherever they may lead. The first part of this resolution follows past precedent used by Democratic and Republican majorities, this time to allow the Judiciary Committee to go to court to enforce subpoenas issued to the Attorney General and former White House General Counsel Don McGahn. The second part reaffirms key language in House rules, making clear that every committee chair retains the ability to go to federal court to seek civil enforcement of their subpoenas when authorized by the Bipartisan Legal Advisory Group. That includes those already issued as well as any future subpoenas. Now, I know some of my colleagues on the other side will be quick to claim this resolution is unprecedented. To them, I would ask this: what is the precedent for an administration refusing to comply with any congressional oversight? No documents, no information, nothing. There isn't one. There isn't one. We have never seen anything like this before. So we need an appropriate response like this because of this administration's constant obstruction. I'm proud that my fellow committee chairs quickly joined in co-sponsoring this resolution, including Oversight Committee Chairman Cummings, Foreign Affairs Committee Chairman Engel, Judiciary Committee Chairman Nadler, Ways and Means Committee Chairman Neal, Intelligence Committee Chairman Schiff, and Financial Services Chairwoman Waters. And I urge my colleagues all of my colleagues to join us. This deserves support from both sides of the aisle. Now, I know the silence from some of my Republican friends to what this president is doing has been deafening. But this moment demands you finally speak up and say enough is enough. This resolution is not about politics or partisanship. It is about defending the rule of law and the very notion of separation of powers. Because the challenge here is so great that if we don't stand up to President Trump today, then we risk losing the power to stand up to any president in the future. So I strongly urge my colleagues, let's make clear that the law still matters, even in Donald Trump's America. We can do that by voting yes on this resolution and making clear that no one is above the law, not even the President of the United States. Let's do right by the American people. Let's restore the dignity of this institution, and let's pass this resolution. I reserve the balance of my time.
The gentleman reserves the balance of his time. Members are reminded to refrain from engaging in personalities toward the president. The gentlelady from Arizona is now recognized.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
Gentlelady is recognized.
Thank you. I rise today in opposition of House Resolution 430. It is disappointing that we are here again debating a measure that will have absolutely no impact on the lives of our constituents. Instead of fixing pressing issues like the security and humanitarian crisis at our southern border, the Democrats continue their focus on influencing the 2020 election at taxpayer expense. Americans are tired of this witch hunt. For nearly 2 years, Democrats claimed that the president colluded with the Russians to interfere in the 2016 presidential election. After 22 months, 2,800 subpoenas, 500 warrants, 40 FBI agents, and spending $35 million, Special Counsel Miller concluded there was no collusion between President Trump and Russia and did not charge him with obstruction. Yet, my Democrat colleagues continue to attempt to undermine the President of the United States because all I can think of is they haven't accepted the fact that he won the election. It is clear to me that the Democrats are trying to influence the 2020 presidential election at taxpayer expense. Americans have real problems we can and should be tackling instead. In May, the U.S. Border Patrol apprehended a jaw-dropping 133,000 people at our southern border. And that's only the people they caught. Yet we are here debating subpoenas targeting the president, probably because it will provide Democrats free airtime. This unprecedented resolution should not even be on the House floor today. It has never been done before in the entire history of the United States. The House has only sued for documents twice before. And in both cases, the individuals in question were first found in contempt of Congress at both the committee level and by the full House. This has not happened here. On top of that, the relevant subpoenas seek material including grand jury materials that by law cannot be made public. The Democrats are asking Attorney General Barr to violate the law. When my colleagues and I tried to improve this resolution, the Democrats blocked us at every turn. I offered an amendment that would let the American people know how much money this resolution would cost taxpayers. Democrats blocked it. Republicans offered amendments to prevent taxpayer money from going to lobbyists, to disclose contracts with lawyers, and to disclose where this taxpayer money was coming from to fund this witch hunt. Democrats blocked each and every one. But one amendment in particular highlights the partisan, political, media-grabbing motives of this resolution. Republicans offered an amendment requiring the Judiciary Chairman to certify that he made a good faith effort to negotiate with the Attorney General, but the Democrats blocked that amendment too. The Attorney General has been transparent, and the Department of Justice has attempted numerous accommodations, including just yesterday, when the Department of Justice agreed to let members of the committee view an unredacted report excluding grand jury material, which by law cannot be released. But even as the Attorney General has attempted to work with Judiciary Chairman Nadler, Chairman Nadler has moved at unprecedented speed, moving from a demand for an unredacted report to subpoena to this resolution in a matter of mere weeks. From the Democrats' actions and prior statements, it is difficult not to view the purpose of this resolution and this debate as anything but political. Mr. Speaker, I reserve the balance of my time.
The
The gentleman from Massachusetts is
Mr. Speaker, I'm
recognized.
happy to yield 2 minutes to the gentlewoman from California, the distinguished chairwoman of the Financial Services Committee, Ms. Waters.
Gentlelady is recognized.
Thank you, Chairman McGovern. I strongly support H-Res 430, which authorizes litigation to compel Attorney General Barr to provide key evidence underlying the Mueller report and the unredacted report itself, authorizes a civil suit to compel Don McGahn to provide the Judiciary Committee with documents and testimony, and prospectively allows committee chairs to bring civil actions on behalf of their committees to enforce their subpoenas without a subsequent full House vote when authorized by the bipartisan legal advisory group. H-Res 430 is key to ensuring that Congress is able to efficiently exercise its constitutional responsibilities in light of the unprecedented stonewalling by the Trump administration and a president who has openly said such things as, and I quote, "We are fighting all subpoenas, and I don't want people testifying." Who does he think he is, a dictator? The committees have requested information that we are constitutionally entitled to as co-equal branch of government, and that we need to fulfill our legislative and oversight responsibilities. In the Financial Services Committee, for example, we have subpoenaed documents from financial institutions, including Deutsche Bank and Capital One, as part of our investigation into the integrity of the United States financial system, bank safety and loan practices, and anti-money laundering policies, including as they are applied to and involve the accounts of President Trump and family members. And so, ladies and gentlemen, in another display of stonewalling, President Trump sued to prevent the banks from complying with the committee's valid subpoenas. I will continue to support efforts to ensure that our critical oversight is not impeded. Who does he think he is? I yield back the balance of my time.
The gentlelady yields back the balance of her time. Members are again reminded to refrain from engaging in personalities toward the president. The gentlelady from Arizona is recognized.
Thank you, Mr. Speaker. I yield 7 minutes to the representative from Georgia, ranking member of the Judiciary Committee, Mr. Collins.
The ranking member is recognized.
Thank you, Mr. Speaker. Mr. Speaker, I rise in strong opposition to H Resolution 430, a resolution authorizing the Committee on Judiciary to initiate or intervene in judicial proceedings to enforce certain subpoenas and for other purposes. This resolution is an assault on this body's constitutional oversight authorities. By proceeding in this unprecedented manner, the House is putting the judicial branch in an unfortunate position. Never before has the House authorized the General Counsel to sue without first exhausting all our constitutional remedies to gain compliance with our oversight demands. Proceeding in this manner risks weakening our ability to carry out our oversight responsibilities. On May 8th, the Judiciary Committee voted 24-16 to hold Attorney General Barr in criminal contempt of Congress. The committee did not pursue contempt against Donald McGahn. Mr. McGahn's case is unique, and I will address it in more detail later. Contrary to press reports, Mr. Speaker, we are not acting today on the contempt citation reported by the Judiciary Committee. We are authorizing the House to sue the Attorney General, Mr. McGahn, and any other official or private citizen any committee chair deems contemptuous in the future. This is a novel, untested, and risky proposition. I'll give it to you this way, Mr. Speaker. The majority is definitely audacious in their request. The media and the Democrats routinely rail against the president being quick to sue. Well, Mr. Speaker, that's exactly what the majority is doing. Having rushed to contempt, we are now bypassing that remedy altogether and going straight to court. Constitutional scholar Jonathan Turley recently wrote, Democrats' litigation strategy is clearly driven more by political than legal calculations. This is the problem I have, Mr. Speaker. These tactics weaken the House. They aggrandize the executive branch and cede decision-making to the judicial branch. This is a problem. The majority can mess up oversight however they want to. The majority can rush to judgment whenever they want to. My chairman has subpoenaed most everything that moves, and it seems other committees are wanting to as well. But here's the problem. When you're rushing to this and you're taking it on grounds that are not legally sound, in which, by the way, at this same hearing where Mr. Turley was at, all three of the Democrat witnesses also agreed that the subpoena of the Attorney General was not legal in the sense that it was asking him to do something illegal. The other issue here is yet that when we practice proper oversight, we are getting documents on election results. We're also getting documents on immigration and others from this administration. Where the rub has come is in overbroad, illegal subpoenas from these committees. Now, they may want to screw it up now for this and their purposes, but I don't want it in the future going forward where this House oversight ability has been tampered by a rush to judgment. Let's think about this institution more than our next headline. This is a problem because it is uncertain here, Mr. Speaker. The House will even be granted standing in court since we have declined to exercise all of our constitutional remedies, namely contempt in its many forms. This is not only the only impediment facing Democrats. At every turn, as we have discussed in our minority views of the committee contempt report, the majority refused to engage with DOJ in the requisite negotiations and accommodation processes. During our markup of the contempt resolution, the chairman made several damaging admissions. This is a chairman of the Judiciary Committee. First, he conceded the Attorney General cannot lawfully comply with his subpoena demanding grand jury material. Second, he stated the subpoena was the beginning of a dialogue. I'm not sure what first-year law student would believe that a subpoena is the beginning of a dialogue. The third, he admitted the subpoena was intentionally broad to give the committee clout in court. Again, not sure which Black's Law Dictionary we're looking up under subpoena, but that's not part of it. All along, the goal has been to get to court, not to get information and conduct legitimate oversight of Russian interference or secure our elections. If Democrats were interested in these good government initiatives, they would have accepted DOJ's offer to review the nearly unredacted Mueller report. To date, Mr. Speaker, the chairman even has not done so. The goal is to clearly haul the administration into court in an attempt to pacify a base rabid for impeachment. When the Congress has exercised its oversight powers, it must take advantage of every offer of information from the other branch. It is disingenuous to decline free information Democrats so strongly claim to want. It shows the majority does not want the information. You want to fight. In addition to the subpoena being overly broad and requiring the Attorney General to violate the law to comply, the chairman failed to establish a valid legislative purpose for his demands. Therefore, are other avenues the chairman could seek to get the information he wants. Congress could pass a law granting itself an exemption to grand jury secrecy rules, but the majority's not brought that up. The most alarming aspect of this action, however, is the unprecedented speed. A mere 44 days passed between the chairman's first request to the Attorney General and the date the committee held him in contempt. In stark contrast, 464 days passed from the date the chairman Issa requested information from Attorney General Holder on Fast and Furious, and the date Oversight Committee held him in contempt. 138 days for Harriet Myers before held in contempt. The action of the majority is authorizing today against Don McGahn, however, Mr. Speaker, is far more egregious for many reasons. Mr. McGahn is not the custodian of the documents the committee and the chairman demands. The White House is. Yet we're smearing a private citizen's reputation and dragging him into court at taxpayer expense in an effort to redo the Mueller investigation because the majority in the media didn't like the outcome. Democrats, again, have failed to lay a foundation for any action against Mr. McGahn. Chairman Nadler has never formally objected to the president's protective assertion of executive privilege or other common law privileges asserted by Mr. McGahn. Under Supreme Court precedent, the chairman must take this important procedural step to pursue further actions against a witness. The witness should be given a clear-cut choice between compliance and noncompliance, between answering the question and risking prosecution for contempt. Here, the witness is being hauled into court without proper notice. Evidence of this glaring error is in the record. On May 31st, Chairman Nadler wrote Mr. McGahn's counsel and stated he did not agree with the White House or Mr. McGahn and offered to continue negotiating. But the chairman also gave Mr. McGahn a deadline of June 7th, this past Friday, to respond. Meanwhile, the Rules Committee noticed a markup of this resolution on June the 6th, one day before the deadline. I think we're seeing the pattern here. This is a revealing error, but errors occur when you're pushing action through at light speed and ceding your power to the judicial branch. A court will decide whether the House has standing, whether the case is right, and whether the Congress is entitled to the information outside of an impeachment inquiry. Also has been said, the propositions are a gamble. Here, Mr. Speaker, we're gambling with the power of a co-equal branch. This approach is untested and can do significant harm to Congress's Article 1 authority. Lastly, Mr. Speaker, I must make mention the authorization of the General Counsel to seek pro bono legal services circumvents the House ethics rules. Can I have another minute?
The gentleman from Georgia, another minute.
The gentleman is allowed an additional minute.
To seek pro bono legal services circumvents House ethics rules. Those rules provide an exception for members to bring civil action challenging the lawfulness of an action of a federal agency or an action of a federal official taken in official capacity, provided that the action concerns a matter of public interest rather than a matter that is impersonal in nature. This resolution contravenes ethics rules by giving the general counsel the authority, in Mr. McGann's case, to solicit a gift, pro bono legal services. I'm not sure that was the majority's intent, but the inconsistencies result when Democrats aim to rush resolutions through the House outside of regular order. Mr. Speaker, the majority may wish to change the rules. The majority may wish to get to the finish line quicker. The majority may wish to circumvent everything that is a precedent in this House, and we've seen a lot of it over the past 5.5 months. But I wish they would take into account that they may not be the majority forever, hopefully. And if they mess up oversight of a co-equal branch, it is on their hands. That is what the vote for yes is on this resolution. That is why a member of this body should vote no for the integrity of this House. I yield back.
Gentleman yields back. The gentleman from Massachusetts.
Thank you, Mr. Speaker. And let me just assure the gentleman from Georgia that there's nothing novel about this legislation. It's not novel because everything in this bill goes to the Bipartisan Legal Advisory Group. And that's been the case in the past. What is novel, however, is a president of the United States who says that ignore subpoenas and we will not cooperate and tells people not to testify. That's not only novel, it is shocking, Mr. Speaker. And I would just say to my friends on the other side, you're going to have a choice today to either vote for this resolution and stand up for this institution and support the rule of law, or you're going to vote in a way that's going to be complicit with this president's obstruction and disrespect for this institution and disrespect for the rule of law. I urge you to vote with us. Mr. Speaker, I yield 4 minutes to the gentleman from Maryland, the distinguished chairman of the Committee on Oversight and Reform, Mr. Cummings.
Before recognizing Mr. Cummings, members are reminded to refrain from engaging in personalities toward the president. The gentleman from Maryland, Chairman Cummings, is recognized.
I rise in strong support of this resolution. Ladies and gentlemen, the Trump administration is engaged in one of the most unprecedented cover-ups since Watergate. And it's not just about Russia. It is so much broader than that. This cover-up spans across numerous investigations, and it extends from the White House to multiple federal agencies of government to completely separate outside parties. The administration officials now question the fundamental basis of Congress to conduct oversight. They object to committee rules and precedents that have been in place for decades under both Republican and Democratic leaders. And they make baseless legal arguments to avoid producing documents and testimony. The Trump administration is challenging the very constitutionality of congressional oversight, and it's happening in broad daylight. Several weeks ago, President Trump vowed, and I quote, "We're fighting all the subpoenas," unquote, end of quote. Since then, he has refused to work on legislative priorities, such as infrastructure, until Congress halts oversight and investigations of his administration. He wants us to forego our responsibility under the Constitution as a condition of passing laws to help our constituents and his constituents. The president's arguments are baseless. He suggests that all subpoenas that Congress puts out are partisan and somehow related to the Russia probe. But that is simply not correct. In the Oversight Committee, we have issued 8 subpoenas. 6 of them are bipartisan, and none of them is about Russia. They involve issues like the census, immigrant children being locked in cages and separated from their families, and the president's finances. This entire year, the White House has not produced one document to the Oversight Committee. Let me say that again. In all of our investigations, the White House has not produced one single shred of paper in response to our requests. The hurricanes in Puerto Rico, the White House has produced nothing. Security clearances abuses, the White House has produced nothing. efforts to transfer nuclear technology to Saudi Arabia. The White House has produced nothing. Hush money payments. The White House has produced not a thing. Even on issues like spending taxpayer dollars to pay for private jets, the White House has produced absolutely nothing. Over and over again, it does not matter what the topic is, the tactics are the same. And this begs the question, what are we covering up? Tomorrow, our committee will vote on whether to hold the Attorney General and the Secretary of Commerce in contempt of Congress for refusing to produce documents relating to Congress. Again, these subpoenas are bipartisan, and this issue has nothing to do with Russia. Yet the Trump administration has delayed, stonewalled, obstructed, and challenged the authority of the Congress on even these questions. I support today's resolution because it makes clear that in addition to seeking criminal contempt on the House floor, committees may seek authority to enforce their subpoenas directly in civil court actions. Nobody is above the law. I need 30 seconds.
30 seconds.
The gentleman is allowed an additional 30 seconds.
Nobody is above the law, even the President of the United States. Today's resolution reaffirms that Congress has the independent authority under the Constitution to investigate waste, fraud, and abuse and wrongdoing so that we can pass laws that are effective and efficient on behalf of all of our constituents. And with that, I urge my colleagues to support the resolutions, and I yield back.
The gentleman yields back. Before proceeding, members are again reminded to refrain from engaging in personalities toward the president. The gentlelady from Arizona is recognized.
Thank you, Mr. Speaker. I yield 2 minutes to the representative from Arizona, my friend, Mr. Biggs.
Gentleman is recognized.
Thank you, Mr. Chairman, and I thank the gentlelady. I oppose this resolution. The subpoena for Attorney General Barr is unenforceable on its face. It demands the full and unredacted Mueller report, including grand jury material that Attorney General cannot lawfully disclose, and the Democrats know this. In a hearing last month, Chairman Nadler admitted that Attorney General Barr could not lawfully release grand jury material. He therefore admitted that the Attorney General could not lawfully comply with the subpoena. Instead, the chairman suggested that the subpoena is a starting point in negotiations. Rarely have I heard that term used with regards to a subpoena. In the Judiciary, in fact, I never heard it before that time. In the Judiciary Committee's hearing on executive privilege last month, one of the majority's own witnesses testified that, quote, one of the categories of information presently sought by the committee appears so broad as to put the executive branch to a nearly impossible task. The committee cannot in good faith expect compliance. Accordingly, the burden is on the committee to substantially narrow this aspect of its request, end quote. My friends talk about the rule of law, but the Democrats have admitted in a hearing in the Judiciary Committee that the subpoena was overly broad and that objects of the subpoena that are prohibited from disclosure, such as 6E material, were not subject to the subpoena. But they didn't fix their subpoena. They didn't issue a new subpoena. They didn't amend the subpoena. They just attempted to amend their contempt citation. Defendants' confusion over what is subject to the subpoena is adequate evidence that the subpoena itself is legally deficient as being confusing and overly broad. And a court will not be able to read the collective minds of our Democratic colleagues and will not expect such clairvoyance from the Attorney General nor from the former White House counsel. The administration is currently negotiating in good faith. We see that an agreement was reached just yesterday. The same Democrat, when discussing the assertion of executive privilege by the administration, stated, quote, these developments do not relieve the committee of its obligation to continue to negotiate. If I might have 15 more seconds.
Thank you, Mr. Speaker. I yield 15 seconds.
Gentleman is
to
allowed
Mr.
15
Biggs.
additional seconds.
Just as a subpoena is overly broad and quite frankly unprecedented, as well as legally deficient, this resolution is also overly broad and unique in the annals of American history. When the chairwoman from California referred to the President of the United States as a dictator, her language was rancorous and unparliamentary, but it seems to have been filled with projection, as this resolution provides unique authority.
The The gentleman from Massachusetts is recognized.
Mr. Speaker, at this moment, I'm proud to yield 1 minute to the distinguished Speaker of the House of Representatives, Nancy Pelosi.
The gentlelady from California, the Speaker of the House, is recognized.
Thank you, Mr. Speaker. I thank the gentleman for yielding, and I thank him for giving us this opportunity to protect and defend the Constitution of the United States, which is our oath of office. Let me salute the chairs of the committees of jurisdiction who have led us down this path with great respect for law, precedent, and the oath we take. Congresswoman Maxine Waters, Congressman Cummings, Congressman Nadler, Congressman Richie Neal, Congressman Elliot Engel, one more, all of whom have been fighting the fight, gathering the facts to protect and defend our Constitution. The oath of office that we take is why we're on the floor today, to hold the Attorney General of the United States, Barr, and former White House counsel McGahn in civil contempt for their refusal to comply with Congress's subpoenas. We must follow the facts and uncover the truth for the American people. At the birth of our democracy, amid war and revolution, Thomas Paine said, "The times have found us." We are here today because the times have found us. While we do not place ourselves in the same category of greatness as our founders, we do recognize the urgency of the threat to our nation we face today. This body has a solemn duty, Mr. Speaker, a solemn duty to protect and defend our democracy, honoring the oath we take, and the Constitution that is the foundation of our freedom. That Constitution begins with our beautiful preamble, "We the people." Immediately following those words of the preamble is Article 1, establishing a Congress in which, quote, "all legislative powers herein granted are vested." The founders conferred upon the first branch responsibilities that are sweeping in scope. We set an agenda, we hold the power of the purse, we write the laws that all of us are bound by, including the President of the United States and those who surround him. Fundamental to those responsibilities is oversight of the executive branch and all of the areas essential to the well-being of the American people. Oversight is our institutional duty to ensure against the abuse of power, protect the rule of law, and expose the truth for the people, who are the, end quotes, "the only legitimate fountain of power," end of quote, in the words of James Madison. To conduct that oversight, the Congress is both constitutionally obligated and legally entitled to access and review materials from the executive branch, which it can subpoena. Yet the President and the administration have shown an unprecedented and unjustifiable refusal to furnish Congress with that information. President Trump himself has said, "We are fighting all subpoenas. I don't want people testifying, no do-overs." His administration has employed every tool it can find to obstruct legitimate committee oversight. Everything from witness intimidation to blanket stonewalling to spurious claims of executive privilege, absolute immunity, and lack of legislative purpose. This obstruction violates decades of established legal precedent. Throughout our history, the courts have made absolutely clear that the House has the authority to follow the facts, to uncover the truth for the American people, and that the power of Congress to conduct investigations is inherent in the legislative process. Those are all in quotes. Our oversight responsibility continues to be resoundingly affirmed in the courts again and again. Last month, the District Court for the District of Columbia ruled in the Mazars Court decision, quote, "There can be little doubt that Congress' interest in the accuracy of the President's financial disclosures falls within the legislative sphere," end of quote. That same week, a judge ruled in the Deutsche Bank case that Congress's, quote, "subpoenas are all in service of facially legitimate investigative purposes." The administration's obstruction not only violates long-established precedent, it endangers our very democracy. We need answers on the many questions left unanswered by the Mueller report. which made clear that the Russians waged an all-out attack on our democracy and documented, the Mueller report documented 11 instances of obstruction from the White House itself. This is a grave threat to our democracy, but the president calls it a hoax and refuses to protect our democracy. Why is that? We take an oath to protect our Constitution from all enemies, foreign and domestic. And what is the White House and the administration are doing is a danger and a threat to our democracy. At the same time, the administration's campaign of stonewalling extends far beyond the Mueller report. The administration is obscuring the truth behind the disastrous policy decisions, from attacking the Affordable Care Act coverage for millions of Americans, including those with pre-existing conditions, and taking it to court to overturn it while saying to the American people, we support pre-existing conditions and the rest. For tearing apart vulnerable immigration families at the border, for stealing military funds for an effective, wasteful border wall, for rolling back key civil rights protections for women, LGBTQ Americans, and people of color. The list goes on and on. Also in court to try to defend their abuse of power when it comes to the census, which the Constitution is very clear about, that every 10 years, the people of the country will be enumerated, and they want to put a citizenship phrase in there to put a chilling effect on our getting an accurate count. The well-being of the American people and the integrity of our democracy are imperiled by this brazen behavior. Yet Senator McConnell declares case closed, enabling this campaign of blanket, unprecedented obstruction. Why aren't the senators we see the obstruction in this House for trying to uphold our proceeding, but we have the votes to proceed. But the United States Senate has a responsibility to protect and defend the Constitution, and they are ignoring that. As members of Congress, we have a responsibility to honor our oath of office, strengthen the institution in which we serve for the people. We have a responsibility to honor the vision of our founders and the text of the Constitution and ensure that the truth is known. No one is above the law. Everyone will be held accountable, including the President of the United States. The People's House will continue to fight to make the truth known for the American people and will defend Congress's role under Article 1. I urge a strong bipartisan vote for this resolution to hold Attorney General Barr and former White House counsel McGahn in civil contempt for their refusal to comply with Congress's subpoenas and honor the oath of office that they take. With that, I urge an aye vote and yield back the balance of my time.
Speaker yields back your time. The delegate from Arizona is now recognized.
Thank you, Mr. Speaker. I yield 2 minutes to the representative from California, Mr. McClintock.
Gentleman is recognized.
Thank you, Mr. Speaker. You know, there's a reason for the abusive rhetoric from the left. For 2.5 years, they peddled a monstrous lie that Donald Trump is a traitor colluding with a hostile foreign government. They concocted it with a phony dossier commissioned by the Clinton campaign and promoted by the highest officials in the FBI, our intelligence agencies, and the Justice Department. First, in a failed attempt to interfere with the 2016 presidential election, and then to undermine the constitutionally elected President of the United States. Now, despite spending $25 million on an outrageously biased team of partisan zealots assembled by Mr. Mueller, which initially included the now infamous Peter Strzok and Lisa Page, and using some of the most abusive prosecutorial tactics ever employed in this country, they could find no evidence to support the lie. So what to do? Well, they had to think up another lie and think it up quick. So now we hear cries of obstruction and cover-up. Well, good luck with that. Cover-up of a crime that never happened, obstruction by turning over every document Mueller requested and even waiving executive privilege to allow the White House counsel to testify. Now, you compare that to Hillary Clinton's willful destruction of 30,000 emails under subpoena, and you get a sense of the double standard involved here. This is a desperate scavenger hunt to salvage a false narrative, and their time and the nation's patience is running out. The other shoe is about to drop. Broad investigations are now well underway and will soon reveal how this lie was perpetrated and promoted. 2 governments interfered in our elections. The Russians through ham-handed propaganda, and the Obama administration by turning the most terrifying powers entrusted to our government against our political process. The reckoning is coming. As Longfellow said, the wheels of the gods grind slow, but they grind exceedingly fine. I yield back.
Gentleman yields back. The gentleman from Massachusetts is recognized.
Mr. Speaker, I yield 2 minutes to the gentleman from Tennessee, Mr. Cohen.
Gentleman from Tennessee is recognized.
Thank you, Mr. Chair. Mr. Speaker, this is an opportunity for Congress to reassert itself as an equal branch of government. And the fact that there's supposed to be 3 equal branches of government, not totally accurate. You know, when we came up with the Constitution, we decided that we didn't want to have an autocratic king rule us. That's why we had a revolution. And when the men met to write our Constitution, they made Congress Article 1. There was a reason they made Congress Article 1, because the Congress represents the people. It's not a king, it's not an autocrat, it's not a despot. It's the representatives of the people to make the laws. We are supposed to really be the embodiment of, and we are the embodiment of the American people. And this president has thumbed his nose at the representatives of the people, not complying with lawful requests for documentation and lawful requests for testimony for Congress to do its constitutional delegated purpose of oversight of the executive and laws that are necessary for the betterment of this nation. This is about time Congress did act. I'm proud of Congress for bringing these bills, and I'm shocked at the opposition for not wanting the people's house, their legislative body, to stand up for future Congresses, as well as this Congress, for the rightful power that it deserves to do oversight and perform its functions with the best possible witnesses and testimony and materials that could aid it in its efforts. So I support the contempt citations. I condemn the parties that have thumbed their noses at us. Subpoena under law. They're supposed to arrive with documentation and appear to testify. And if they object, they can object there and then, not just disregard Congress's subpoenas that are lawful. I yield back the balance of my time.
The gentleman yields back. The gentlelady from Arizona.
Thank you, Mr. Speaker. I yield 2.5 minutes to the representative from Georgia, Representative Woodall.
The gentleman is recognized.
I thank my friend on the Rules Committee for yielding. And Mr. Speaker, I've been listening to this debate intently. I don't disagree with much of what my friend from Tennessee had to say. It is a bad habit that both parties have gotten into over the decades of my lifetime, putting party above article in terms of judicial oversight, executive branch oversight, and even our responsibilities here, such as declaring war. But what you have not heard here today, Mr. Speaker, and what you will not hear, is why the passage of this resolution advantages us in any way. There is not one piece of information that the Speaker of our House, our Speaker, just came and asked for that we are not empowered to request today. The difference, Mr. Speaker, is if we pass this resolution, rather than the House requesting this information, as has historically been true, we would begin to request information one committee chairman at the time. Does that advantage us in Article 1, going to court one committee chairman at the time? Or are we advantaged when the Speaker speaks on behalf of us all? I don't know the answer, Mr. Speaker. I'm not a legal scholar, and in the Rules Committee, where we had original jurisdiction on this, we did not call any legal scholars to help us answer that question. In the Judiciary Committee, they did not call any legal scholars to help to answer this question. Mr. Speaker, I tell you, there is not a member of this institution on either side of the aisle that cares more about Article 1 and us exerting the responsibilities the Constitution gives to us and our constituents expect us to do than I do. Perhaps there is someone in here who cares as much, but there is no one who cares more. Are we disadvantaging the institution for life by taking what has traditionally been the responsibility of our Speaker to do on behalf of all of us and putting it in the hands of committee chairmen. We don't know, and anyone who tells you that they do isn't telling you the truth. We're going to continue to argue about the White House and what they turned over and what they didn't turn over and what they ought to turn over, Mr. Speaker. That is not what this bill does today. There is not one piece of information that's requested that we do not have the authority to request today. Let's not move in ways that could disadvantage us for generations to come. Thank you, Mr. Speaker.
The gentleman from Massachusetts is recognized.
Mr. Speaker, I'm proud to yield 1 minute to the gentleman from Maryland, the distinguished Majority Leader, Mr. Hoyer.
The gentleman from Maryland, the Majority Leader, is recognized.
Thank you, Mr. Speaker. I'm pleased to follow the gentleman from Georgia. I have a card in my hand. This is a member's identification. There is no designation of party on this card. This card designates 435 of us, when we're at full complement, as members of the Congress, the people's representatives. And I urge all my colleagues to use this card in a few minutes on behalf of the people and on behalf of this institution. Mr. Speaker, when Democrats won the majority in this House, we did so on a promise to the American people to hold the executive department accountable. That is our responsibility. The Constitution gives us that responsibility, and we swear an oath to uphold the Constitution. That is what the committees have been doing, and it is when the whole House is what the whole House is doing today. Now, the previous speaker said we have the right to ask for any information. That's accurate. What he did not then say is we have asked and we have been refused. Not only have we been refused in the particular, we've been refused in the general, because the President of the United States has directed his people not to give us any information, not to respond to any subpoenas. Whatever the rationale may be. Why? Because he believes the House of Representatives is not acting properly. My colleagues, can't you imagine anybody who doesn't want to give us information would say, I'm not going to give it to you because you're not asking properly? Of course, that's what they do. And the House, on behalf of the American people, would be unable to perform its constitutional duty. This is not political. It's constitutional. It's about separation of powers. It's about responsibility. It's about accountability. The House is exercising its responsibility to uncover all the facts and discover the truth on behalf of the American people. We represent, each of us, about 750,000 people. We're not asking in our own behalf. We are asking for the people, so that the people have the information they need in a democracy to make the decisions that they are called upon to make. In a very solemn exercise, we call it voting. Attorney General Barr and former White House counsel McGahn have both refused to respond to subpoenas to testify before the House. And the Attorney General refuses to allow Congress to see the full and unredacted report by the special counsel, Mr. Mueller. You can see entire pages blacked out. The Attorney General's efforts to prejudge the conclusions of that report before it's released, as he did, and his public mischaracterization of its conclusions are, in my opinion, evidence of the contempt with which he refuses to answer questions and respond to subpoenas. It seems contemptuous as well of the basic principles of the rule of law and checks and balances. The American people deserve to know the full extent of Russia's efforts to interfere in our elections and subvert our democracy. You didn't have to listen too closely to Bob Mueller to understand that he believed that there was much more to be found, or to miss the fact that he said, Congress, do your duty. Make sure the American people know the facts. The American people deserve to know whether the president or anyone in his administration or inner circle of confidence were involved and tried to cover it up. Now, we've been accused of doing awful things, but I remember watching conventions where they said, lock her up. Lock her up. Flynn, General Flynn, who was the national security advisor, said, lock her up. Well, the fact is they locked him up. And many others associated who lied about their involvement with the Russian government, and yes, with other foreign countries. So there is reason for the Congress to want to get to the bottom of this serious invasion of our election process. I urge my colleagues on both sides of the aisle to stand up for our Constitution and vote for this resolution. I thank the chairman of the Rules Committee, Mr. McGovern. I thank Chairman Nadler, Chairman Schiff, Chairman Cummings, Chairman Neal, Chairman Engel, Chairwoman Waters, all who have jurisdiction over various facets of the information that is needed. And I thank the members of their committees for their hard work to conduct necessary oversight on behalf of the American people. Mr. Speaker, that's what this vote is about. I presented that card. It has no party designation on it. It just has a designation of us, each of us, as representatives of the people. Let us make sure that today we vote for the people. Stand up for our Constitution and for this House and for the rule of law. And I yield back the balance of my time.
The gentleman yields back. The gentlelady from Arizona is recognized.
Thank you, Mr. Speaker. I yield 2.5 minutes to the representative from Ohio and my fellow Judiciary Committee member, Mr. Shabbat.
The gentleman is recognized.
I thank the gentleman for yielding. Mr. Speaker, I rise in opposition to this resolution. It seeks to allow Democrats on the Judiciary Committee to go to essentially whatever court they want to get a court order, to get whatever documents they want, even grand jury documents and those that relate to our national security, all because they don't want to, or are afraid to really, hold Attorney General Barr or former White House counsel Don McGahn in contempt of Congress, just as they're afraid to initiate impeachment proceedings against President Trump, or accept the fact that the Mueller investigation found that there was no collusion and Attorney General Barr found no obstruction. They just can't get it through their heads that that's the case. And they don't want to focus on the real issue threatening our democracy, which is that Russia actually attempted to interfere in our national elections back in 2016, while Barack Obama, not Donald Trump, Barack Obama was president, and the Obama administration did absolutely nothing about that. They don't want to seem They really don't seem too concerned that the Russians or another foreign entity might attempt to do so again in 2020. That's what they ought to be using their oversight powers, very powerful things, the power that the majority has. They ought to be using it about that, not this charade. How many documents have the Democrats requested that relate to Russian interference in our elections? None. How many hearings? Zip. How many Obama administration officials and others connected to Russia's efforts have they subpoenaed to testify before the Judiciary Committee? Zero. By continuing with this fake impeachment, the Democrats are doing the American public a disservice. My Democratic colleagues ought to be embarrassed. I yield back my time.
The gentleman yields back. The gentleman from Massachusetts.
Thank you, Mr. Speaker. And let me just say to the gentleman from Ohio, let me just correct the record. The Russians didn't attempt to interfere in our election. They did interfere in our election. And if my friends read the Mueller report, they'd realize they interfered in the election to help Donald Trump get elected. Mr. Speaker, I'd like to yield 3 minutes to the gentleman from New York, the distinguished chair of the Committee on the Judiciary, Mr. Nadler.
The gentleman from New York, Chairman Nadler, is recognized.
Thank you, gentlemen, for yielding, Mr. Speaker. When a congressional committee issues a subpoena, compliance is not optional. We expect witnesses to testify when summoned. We expect the administration to comply with subpoenas and to provide us with the materials we require to do our jobs. Of course, there may be differences between the Congress and the executive branch as to what information can be produced on a timely basis. When those differences arise, we are required to seek a reasonable accommodation. We first requested access to the full Mueller report and the underlying evidence on February 22nd. After refusing for almost 4 months, the Department of Justice in the last few days has finally agreed to permit us to view the special counsel's most important files. We are hopeful this will provide us with key evidence regarding allegations of obstruction of justice and other misconduct. Given this potential breakthrough, we will hold the criminal contempt process for Attorney General Barr in abeyance for now. But President Trump has blocked other key witnesses from testifying before the Judiciary Committee, including his former White House counsel, Don McGahn, whose account of the president's actions was featured in the Mueller report. The president has claimed absolute immunity for critical witnesses to prevent them from even showing up. He has invoked executive privilege to prevent us from seeing documents that stopped being privileged long ago, if they were ever privileged to begin with. He has done the same in response to Congress' important work unrelated to the Mueller report, and he has ordered the agencies not to cooperate with even our most basic oversight requests. This unprecedented stonewalling by the administration is completely unacceptable. The committees have a constitutional responsibility to conduct oversight, to make recommendations to the House as necessary, and to craft legislation that will curb the abuse of power on full display in the Trump administration. This is why it is important that the Judiciary Committee be able to act in such matters using all of our Article I powers as contemplated in this resolution and described in both the Rules Committee report and the House Judiciary Committee's contempt report. Now, I heard what the gentleman from Georgia, Mr. Woodall, said a few minutes ago, and he is exactly right. This resolution gives committee chairs the power, with the approval of the Bipartisan Legal Advisory Group, to go to court on behalf of the House to enforce our subpoenas. This has not been done before, but neither have we ever seen blanket stonewalling by the administration of all information requests by the House. We have never faced such blanket stonewallings. The president himself said, and they've been as good as their word, they will oppose all of our subpoenas. We must go to court to enforce the subpoenas without a separate floor vote each time if we are going to enforce our subpoenas and reject the arrogant assumption of power and by the administration and denigration of the power of the House and of the Congress. We cannot afford to waste all the floor time for every single time the administration rejects one of our subpoenas, which is every time we issue a subpoena. That's why we must do this resolution. I urge my colleagues to support this resolution so that we can get into court and break the stonewall without delay. I yield back the balance of my time.
Gentleman yields back the balance of his time.
Thank you, Mr. Speaker. I yield 1 minute to the representative from California, our Republican leader, Mr. McCarthy.
The gentleman from California, the Republican leader, is recognized.
I thank the gentlelady for yielding. Mr. Speaker, Special Counsel Mueller officially ended his investigation several weeks ago. His office is closed. Because of Attorney General Barr, his report is public, and his findings are very clear. No collusion and no obstruction. This is the bottom line of the Mueller report. But Mr. Speaker, Democrats refuse to accept it. Mr. Speaker, even the chairman of the committee refuses to go read the portion that he's allowed to read, only 6 lines. He refuses to read it, but he wants to come here today. They continue to believe their worst conspiracy theories about the president, despite all the evidence to the contrary. Mr. Speaker, it's even reported in newspapers in the campaign to become chairman of the Judiciary Committee, one said he campaigned for the position because he would be the best with impeachment. Mr. Speaker, even on this floor of this House, there were more than 60 members of the other side of the aisle who voted for impeachment before the Mueller report was ever presented to the public. At its core, House Res 430 is just a desperate attempt to relitigate the Mueller investigation. That's why I urge colleagues to oppose this resolution. It does not strengthen Congress' oversight powers, contrary to what you may hear from the other side, Mr. Speaker. Fundamentally, it is an impeachment effort in everything but name. Mr. Speaker, just look at the unnecessary contempt citation against Attorney General Barr. Less than a month after Barr received the Mueller report, Mr. Speaker, Chairman Nadler issued a subpoena that would have required the Attorney General of the United States of America to break the law. That's not my opinion. Let's be very clear whose words those are. Jonathan Turley. Mr. Speaker, probably everybody in this body not only knows who Jonathan Turley is, he has probably the utmost respect. He is one of the most respected legal scholars in this country. Now, he told the committee, Mr. Speaker, and I quote, "You have to tie your request carefully to your authority to demand information. If Bill Barr had actually compiled with the subpoena as written, he would have violated federal law. If he would have complied, he would have violated federal law." Mr. Speaker, that's why we're here. Not only, Mr. Speaker, does the chairman of that committee ask the Attorney General to break the law or he will try to hold him in contempt, he won't even go read the report. On May 8th, only a few weeks after the first subpoena was issued, House Judiciary Democrats voted to hold A.G. Barr in contempt, the Attorney General of the United States in contempt. Why would they vote to hold him in contempt? Because they were so angry that the Attorney General wouldn't break the law. They wanted him to break the law, then you won't be held in contempt. In a May 24th letter to the Attorney General, Chairman Nadler offered for the first time to negotiate and narrow the scope of his subpoena request. But then you know what? He changed his mind. Yesterday, the Department of Justice reached an agreement with the Judiciary Committee to turn over documents related to the Mueller report. Now, if the public's watching, this just looks so disorganized. You wonder, from that committee, Mr. Speaker, wouldn't they know better than to ask the Attorney General to break the law? Mr. Speaker, wouldn't you know that when you get to this point in a career, that you wouldn't be so upset that someone just doesn't do exactly what you want and then you ask you to break the law, that you'd vote to hold them in contempt and force your side of the aisle just to vote that way? That's not how it's happened in this body before. If the public wants to see a good example of congressional oversight, then let's look at something that's comparable. The House's contempt vote against Attorney General Holder in 2012. The House Oversight Committee took two important actions before suing in federal court. First, it negotiated with Attorney General Holder in good faith for 15 months, not a few days. It never asked him to break the law either. Narrowing the scope of its original subpoena only extensive back and forth negotiations failed did it vote to hold him in contempt. Second, it got the full House to vote on it and prove, you know what? A bipartisan contempt. Now, I'm not sure why this committee of the judiciary, Mr. Speaker, would not know this, but I did a little research because I was here during that time. You know why they didn't realize it was the best way to do it and it was bipartisan? Because, Mr. Speaker, a lot of them stormed outside of the chambers. Yep, you heard me right. Even though 17 Democrats voted in favor of the criminal contempt resolution against Holder and 21 voted to enforce civil citation, a number of them stormed outside and protested, took their ball and ran home. Mr. Speaker, I guess the public looked at it just throwing another fit. Now that's pretty significant. As many of you remember, it was contentious. I remember, Mr. Speaker, watching then Minority Leader Pelosi, Minority Whip Hoyer, and Congressman Nadler lead 100 Democrats off the House floor to protest the vote. Mr. Speaker, you won't see that on our side. We believe in the rule of law. Mr. Speaker, we would have done the exact same thing the Attorney General did to Jonathan Turley, said that you would have had to break the law to try to appease somebody's own personal vendetta. The idea that, Mr. Speaker, that someone would run for a position to say that they'd be best to impeach somebody and even vote to impeach without even having a report, and then when you get a report and you could go down and read just those 6 lines that you want to complain about, but you won't. The same person, Mr. Speaker, that would run outside and say, I got elected to Congress, but I'm going to pout and I'm going to go outside. Mr. Speaker, that might be the same person that want to bring this to the floor today. But what is so different about today than all the others? Well, we're doing something we've never done before. We're doing something that's going to take the power away of every member in this body and give it to a select few. Mr. Speaker, if this vote passes today, members of this body are going to say, don't bring it here and let me represent my own people and vote about going to court. Let's just give it really to 3 people. Let's give it to Speaker Nancy Pelosi, Majority Leader Hoyer, and to the Majority Whip. Because that's what BLAG is. I know the courts are going to sit there and say, that's not what Congress is supposed to do. Congress has never done that before. But you know what? If this new majority thinks all they want to do is make an attorney general break the law, I guess they could break every rule, every history, every point of representation there is inside this body. Did we wonder if this would happen? Do we wonder why you wouldn't take the months as they've shown in the time before and actually come to a bipartisan conclusion? I think the plan was already written. I don't know if people can talk about the word patient, because, Mr. Speaker, I remember Congressman Hank Johnson of the Rules Committee. This is the Speaker's Committee, so everybody understands correctly that it's just appointed by the Speaker on the majority side. And he said, Mr. Speaker, Donald Trump will stand for re-election again in a very short period of time, and we don't have 400 days to wait. So don't care about the rule of law. Don't care about asking him to break the law. Just break every historical trend and try to take the power away from millions of Americans, of the members of Congress who represent him here. I didn't know today would come. Mr. Speaker, I didn't know that someone would go this far. I didn't know just because someone, Mr. Speaker, despises somebody else, that an election didn't turn out the way of the desire. Mr. Speaker, I've been on losing sides before, but I'd never think I'd break the law just because You lost an election. I'd never think of asking somebody as high as office as the Attorney General of the United States of America to not give due process, to come to the floor and strip the power of 430 members and put it in a select few. But Mr. Speaker, I have to be honest. I don't put anything past what this new desire is about. Mr. Speaker, Democrats say we're on a constitutional crisis, and they're right. But not because of Attorney General Barr. The true constitutional crisis is this. When Democrats can't win, they change the rules. I just heard it on the floor, Mr. Speaker. That yes, from the other side of the aisle said this has never been done before. And yes, this is nothing this House has ever desired to do. But it's also no way to govern. The American people deserve a majority that is serious about coming up with solutions, not subpoenas. There are plenty important challenges that we can be working on to solve. Just yesterday, Mr. Speaker, I opened the New York Times. It's not a paper that I think always I agree with, but it had an editorial, not for the first time, but for the second time. And it was talking about the crisis on the border. And as I read this editorial, I found myself agreeing with it greatly. When I read it, it talked about the border, it talked about Washington to stop dithering and do something about it. And I looked to wonder what committee would be most responsible for this challenge. Lo and behold, it was Judiciary. So I turned it on in hopes that I would see a hearing. Maybe I'd even see a markup. No, Mr. Speaker, who did I see? I saw John Dean. John Dean, who pleaded guilty in Watergate, the same individuals that's put more than 900 tweets out against the president, many before any Mueller report came forth. He was the expert witness. The same individual who's paid by CNN, the same individual who said the presidency of George Bush was worse than Watergate. I guess this new majority will go to no end. It doesn't matter if the facts don't go where you want, just change the rules. I wonder, all these new freshman Democrats, Mr. Speaker, when they swore in to uphold the Constitution, does that mean trying to make the Attorney General break the law? Does that mean giving your power away to a select few? There is a crisis on the border. The New York Times knows it. The country of Mexico knows it. I think almost everybody in America knows it, except, Mr. Speaker, I guess this majority. The Committee of Responsibility is more concerned about bringing somebody in who pleaded guilty in Watergate, who makes their money off, Mr. Speaker, of writing books claiming every Republican president there is worse than Watergate, and then asking the Attorney General to break the law. That's not a legacy I would be proud of. It's not a legacy I'd want to be a part of. But, Mr. Speaker, I will stay on this floor. I will vote against taking the power away, even the power away from people on the other side of the aisle. I won't lead a protest, and I won't go outside, and I won't take my ball, and I won't run home. I believe in the rule of law. Mr. Speaker, I had the responsibility and the opportunity that I could go read the redacted portions of the Mueller report, just as some on the other side of the aisle could. It's just 6 lines. Not did I think it was just my responsibility, but as an elected official, I thought it was a responsibility, so I went. But, Mr. Speaker, the people leading this today, they have not. They think they know better. I don't know if they know better, but one thing I do know, they're changing the rules of the House simply because they cannot win. That's not the American way. Those are the reasons why we stand up. Those are the things that America unites behind, the rule of law. This will not be a day that's proud. This will not be a day that when they look back in history, the individuals who vote for this will talk about. It's one when they get asked a question later in life, Mr. Speaker, is there something they regret? They'll regret the emotion overtook them. They regret their own personal dislike drove them. I'm not sure if they're proud of the day when they storm out of the building, even though there's a bipartisan vote here. But I guess that same emotion, the same, Mr. Speaker, lack of ability to actually look at the rule of law and work towards something instead of just changing the rules because you can't have your way, that's what today's about. But the worst part of it all is removing the power of individual members and putting in a select three. But then again, Mr. Speaker, when you study history and forms of government, that's what socialism is all about. I yield back.
The gentleman yields back. The gentleman from Massachusetts.
Thank you, Mr. Speaker. Mr. Speaker, the distinguished minority leader began by saying that the Mueller report makes it clear that there was no collusion and no obstruction. Maybe that's what you would conclude if you just read the Barr summary, which tried to cover up what the Mueller report said. But I would urge the distinguished minority leader to read the report. I'm happy to lend him my bifocals if he has trouble reading it. But the report doesn't say that. It says it doesn't say no collusion. And on the issue of obstruction of justice, it says if we were convinced that he, the president, did not commit a crime, we would have said so. That's what the report says. And I would remind my colleagues that obstruction of justice is a crime. At this point, I'd like to yield 2 minutes to the gentleman from California, Mr. Liu.
Gentleman from California is recognized.
Thank you, Mr. Speaker. The issue today is very simple. It's simply about the right of American people in Congress to get information. That's it. All this resolution does is it allows us to enforce congressional subpoenas. These are documents and witnesses we want, and allows us to go to federal court to enforce it. That's all this resolution does. And why are Republicans so scared of this resolution? Because they know we're going to win in court. We won 3 times against the Trump administration. But why do we even have to go to court to do this? Because the Trump administration is engaging in an unprecedented obstruction. And it's not just about the Mueller report, it's about all areas. So for example, right now, the Trump administration is suing to eliminate healthcare coverage for people with pre-existing conditions. We want to know more about that. We can't get it. We want to know about a lot of areas that we cannot get. So we want to go to federal court to get this enforced. And what are Republicans doing? They're making stuff up. They're saying somehow we're asking the Attorney General to do things that will make him violate the law. That is wrong, wrong, wrong. And I'm just going to end with this simple example. The Attorney General of the United States gave the Republican ranking member of the Judiciary Committee the right to see their unredacted Mueller report. Was that illegal? No. But I can't see it. That is wrong. There's no basis for that. We're simply going to go to federal court. We're going to litigate it. We're going to win. And all this resolution does is allows us to enforce congressional subpoenas in federal court. It's about not allowing the Trump administration to cover things up. I yield back.
The gentleman yields back. The gentlelady from Arizona.
Yes, Mr. Speaker, I yield 2 minutes to the representative from Texas, Mr. Gomer.
Gentleman from Texas is recognized.
Thank you, Mr. Speaker. This is about harassing the president, and it's about delaying the inevitable. I would have hoped that my friends across the aisle, especially in the Judiciary Committee, that had concerns in 2005 and 6 about the overreach that was possible through the FISA procedures, would have seen that there was no collusion, that the Russians did try, but nobody with the Trump campaign bought. And so we're left with the fact that the real collusion here was between the Clinton campaign with Fusion GPS, hiring a foreign agent, Christopher Steele, who talked to people he now admits could well have been agents of Vladimir Putin, who gave false information about Trump, the candidate, that was used in a dossier that was used to manipulate the FISA court into giving a warrant to start spying on the Trump campaign. That's what this was about. And what people are calling obstruction of justice is exactly what you have when you have somebody falsely accused of colluding, conspiring with the Russians, and he knows he didn't do that, and he sees his family being harassed, and everybody that worked with the campaign that can be pushed and shoved and blackmailed, as happened, and bankrupted. You want to bring it to an end. You want to see justice done. But instead of my friends in judiciary coming together with us that have been concerned about the abuses of the FISA system so that it doesn't happen to other Americans, instead, they come with this resolution to push the matter down the road a little further to the 2020 election. It's got to stop. Let's stop now. I yield back.
Gentleman yields back. The gentleman from Massachusetts.
Mr. Speaker, I'm delighted to yield 2 minutes to the distinguished gentleman from Texas, Ms. Jackson Lee.
Gentlelady from Texas, Ms. Jackson Lee, is recognized.
I thank the gentleman. I think it is appropriate to correct a number of statements that have been made on the floor. First of all, this is not the end. Director Mueller made this the beginning. When he concluded the report, he left a very large direction to the United States Congress. He recognized that he could not follow up because of policies at the DOJ regarding indictment in the process of the administration. And so the Congress, in its due diligence, took the responsibility not to target anyone, but to simply uphold the rule of law. In upholding the rule of law, we had an empty seat by Attorney General Barr, an empty seat by Mr. McGahn, an empty seat by Ms. Hicks, Ms. Donaldson, and we hope not an empty seat of the author of the report. So all this resolution does is authorize the committee to seek civil enforcement of its subpoenas against Attorney General Barr, requiring him to provide Congress with the key evidence underlying the Mueller report, as well as the unredacted report itself, and former White House counsel Donald F. McGahn, requiring him to provide documents and appear for testimony. He's not covered by executive privilege. In fact, executive privilege does not cover his duty is to the White House office of the general counsel, or the White House counsel's office, not to the individual office holder, the president. He has personal lawyers. And we didn't break the law. 6E, which is grand jury materials, our committee diligently said, let's work with the Department of Justice, go to court and decide what we can see. We are simply following this little book that many have died for, and that is the Constitution of the United States. And those words in the Declaration of Independence that said we all are created equal with certain unalienable rights of life and liberty and the pursuit of happiness. The American people would not want a nation that did not hold.
I yield the gentlelady additional 1 minute.
Gentlelady is allocated an additional minute.
The American people would not want a Congress that turned its back on, frankly, the rule of law. And for those of us who had the special privilege of going to Normandy this past week, you got a great sense of pride, of the courage of Americans, the bravery of those young men. And all I could think of is how important it is for all of us to adhere to those wonderful principles. So again, there is no targeting here. This is not a way to do policy or legislation. We can fight that battle on the floor of the House. But if you read those volumes and end it in the last pages of volume 2, you know that Director Mueller asked us to finish the task of looking into elements that he did not or could not in the underlying issues. Let me also say, as we do that, we do it forthrightly, because in 2020, we want to make sure that every American has a right to vote, and every American is not undermined by a foreign operative interfering and taking the election away from you. I support the resolution. We must stand for the rule of law. I yield back.
The gentlelady yields back. The gentlelady from Arizona.
Thank you, Mr. Speaker. I yield 2 minutes to the representative and fellow Judiciary Committee from Virginia, Mr. Klein.
The gentleman is recognized.
Thank you, Mr. Speaker, and I thank the gentlelady for yielding time.
And I want to recognize the gentlelady from Texas for her remarks, because as a fellow member of the Judiciary Committee, we all stand for the rule of law. And I too carry a Constitution with me. And the Constitution explicitly creates a system that is representative of the people, where the people are elected by their constituents to come up here and represent their views in Congress and vote for them. It's not to come up here and to hand off control, to hand their vote to the majority leader, to the speaker, and to the majority whip, and to let them vote for them and for the people of their district, whether or not to go to court. The votes to enforce subpoenas, the votes to hold in contempt, should be votes of the representatives of the people. That's why this resolution today is such a travesty. Mr. Speaker, I've only been a member of this body for a few months, and I was proud to be named a member of the Judiciary Committee. But unfortunately, the circus that I've witnessed over the last few months is shocking, as the Democratic majority tries to find some reason, any reason, to impeach this president now that the Mueller investigation has wrapped up with no crimes found. If they want to go back and repeat the last 2 years of the investigation, the millions of dollars, the hundreds of subpoenas, they are certainly entitled to do that. But I would argue it would be a waste of time of the American taxpayer and the American people. You know, we had a hearing earlier today on the 9/11 Victims Compensation Fund, and the chairman did a masterful job of arguing in favor of that legislation, of which I'm a co-sponsor. It's bipartisan legislation. It's going to be marked up tomorrow. That's the way that this Judiciary Committee should operate. Instead, we have hearings with empty chairs for the Attorney General. We have a hearing with empty chair for the White House counsel. Finally, yesterday, we had a hearing with people in the seats, but they were all MSNBC and CNN commentators. Mr. Speaker, this is a travesty of justice. I would urge my colleagues to defeat this resolution.
The gentleman's time has expired. The gentleman from Massachusetts.
I reserve my time.
The gentleman reserves. The gentlelady from Arizona.
Thank you. The Committee on the Judiciary is one of the most venerable in the House of Representatives, and I am honored to have been selected to join its ranks. It has jurisdiction over intellectual property during a time of exponential scientific breakthroughs. It has jurisdiction over election interference during a time when we are concerned about Russians interfering with our election. It has jurisdiction over immigration issues during a time of an unprecedented security and humanitarian crisis on our southern border. I am disappointed to see how the Democratic majority has chosen to waste this authority. I am disappointed to see that it has chosen to ignore its responsibilities to the American people in favor of sound bites and photo ops. Instead of legislating, the Democratic majority prefers posing with buckets of fried chicken for the national media in crude attempts to undermine our president and his administration. Really, it's time to move on and tackle the real issues that Americans care about. The American people elected us. They elected me to Congress to get things done. Let us secure the border. Let us improve health care. Let us improve education. Let us stop this political theater that happens meeting and hearing after hearing in multiple committees. And what I believe is a blatant attempt to influence the 2020 presidential election using taxpayer resources. Mr. Speaker, I reserve my time.
The gentlelady reserves her time. The gentleman from Massachusetts.
I have no further speakers. If the gentlelady is through, if she yields back her time.
Thank you. I have an inquiry. How much time do I have left in the other side of left, sir?
The gentlelady has 1 minute remaining.
Well, thank you, Mr. Speaker. I'm going to use my 1 minute to talk about to actually refute these blatant allegations and fantasies, I believe, by my fellow Democrats. And that's how somehow the president and the Department of Justice has been stonewalling them. Let me go over the timelines real quick. On March 22nd, the Attorney General immediately notified the chairman and the ranking members of the House and Senate Committees on Judiciary that they had received the confidential report from the special counsel. The next day, the Attorney General informed Congress of the special counsel's principal conclusions. March 29th, he updated the Congress on what could be done and what redactions had to be made. Then on April 18th, less than a month after receiving it, the Attorney General made the redacted confidential report available to Congress and the entire public. The same day, the Attorney General released the confidential report and made the minimally redacted version of the confidential report available for review. Mr. Speaker, I would urge a no vote on this resolution, and I yield back the balance of my time.
The gentlelady's time has fully expired. The gentleman from Massachusetts.
I yield myself the remaining time, Mr. Speaker.
Gentleman is recognized.
Mr. Speaker, my friends on the other side, have responded to this legislation with the same old, same old. They're circling the wagons around this president and his team. They are deliberately turning a blind eye to the corruption, to the deception, to the illegality that has surrounded this White House. But let me remind them all of why we're here today. We're here because the American people elected each of us to write laws and to ensure those who execute them are held accountable. We all took an oath when we were sworn in to uphold and defend the Constitution. That's our job. None of us were sent here to play defense for the President of the United States. There are some things that are more important than politics. And I hope that even in this day and age, there are still some things that are more sacred than partisanship, like the rule of law and the separation of powers. I mean, each of us took the same oath. We now have a choice whether or not to uphold it. The choice should be a simple one: to stand up to President Trump and to defend the Constitution. I remember when many of my Republican friends ran for office claiming to be constitutional conservatives. Well, this is your chance to back up your campaign slogan with your vote. We have a president that publicly states, we're fighting all subpoenas, and I don't want people to testify. Those are his words. Those are the words of the president, not some mob boss. And as we heard from the chairman of the Oversight and Reform Committee, Chairman Cummings, the White House hasn't turned over a single document, a single piece of paper that his committee has requested to do their oversight work. Not one piece of paper. At the core of this resolution is Congress getting the appropriate documents so we can do the appropriate oversight. That's part of the job. How can anybody be against that? To be against that is to be part of the cover-up, is to be complicit with the obstruction that this White House demonstrates each and every day. I remind my colleagues that history will judge how we react to this moment. So I urge all of my colleagues, do not let this moment pass us by. Vote yes on this resolution, and let's hold the president accountable. Nobody is above the law in the United States of America, not even the president of the United States. With that, I yield back the balance of my time, and I urge a yes vote.
The gentleman's time has expired. Members are again reminded to refrain from engaging in personalities toward the president. All time for debate has now expired. Pursuant to House Resolution 431, the previous question is ordered on the resolution as amended. The question is on agreeing to the resolution. Those in favor say aye. Those opposed, no. The ayes have it. The resolution is agreed to.
Mr. Speaker, I
Gentlelady from Arizona.
Mr. Speaker, I ask for the ayes and nays.
The yeas and nays have been requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. Pursuant to Clause 9 of Rule 20, this 15-minute vote on adoption of the resolution will be followed by a 5-minute vote on the motion to suspend the rules and pass H.R. 2608.
This is a 15-minute vote.
And a final vote now here in the House on the resolution dealing with subpoenas for Attorney General William Barr and former White House counsel Don McGahn. If approved, the chairs of House committees would have an expedited process to enforce future subpoenas through legal action, needing only the approval of a majority of Democratic and Republican leaders. In this vote, a simple majority needed for passage.